Okay, I don't see any hands, so let's go ahead from the judicial branch. We have our court administrator, Mr. Jeff Shorba, present, and we have Janet Marshall, the intergovernment relations staff from the state Supreme Court. So, however, the courts would like to proceed. The floor is yours.
Mr. Chair, do you want to call on Senator Limmer? I see his hand is up before I start.
Oh, thank you. I did not see that. Senator Limmer.
Can you hear me, Mr. Chairman?
Yes, I can, sir.
Can you see me?
I can, Senator Limmer.
Okay. My state Senate computer is not populating since last few days. So I'm on my iPad. And so this is a new experience using this equipment. I just wanted to make sure that we're connected. I did want to advance a message to you. Senator Eichhorn, thinking that the Senate was not working today, scheduled meetings with his constituents, and he won't be available until early afternoon. And Senator Howe, knowing the same thing, scheduled some business appointments, not knowing that there was going to be a judiciary meeting. So just want to, he wishes, both of them wish to be excused for the time that I described.
That is fine. They can be excused until they're able to join us. I will note for the record that we did send out an email at one point in response to a leadership memo saying that everything was canceled on Friday. And then very shortly after that, I sent out an email to the same listserv group that we should hold off on canceling Friday and should in fact keep the time available because we might in fact be having a hearing in the event that we could make the arrangements to do so. But I understand it's been a difficult week for everyone, and we hope that Senator Howe and Eichhorn can join us as soon as they're available.
All right. Thank you.
All right. Thank you. Anyone else speak up, I guess, before we go into the judicial branch presentation? Senator Limmer, you can go ahead and put your hand down then when you have a moment. All right. Mr. Shorba, who desires to open the judicial branch presentation?
I'll be doing it, Mr. Chair. So good morning, everyone. Chair Latz, members of the committee. Sorry we're not there in person. I know there are some of you I've not met in person yet, but we'll be coming soon to your offices to meet. So my name is Jeff Shorba, and I have the pleasure of serving as the State Court Administrator for the Minnesota Judicial Branch. And I'm pleased to be with you today to give you an update on Minnesota's third branch of government and to seek your support for our fiscal year 24-25 biennial budget request. At the outset, I want to share our appreciation to Governor Walz for including the entirety of this important funding request in his biennial budget recommendations to the legislature. We are hopeful that you and your colleagues in the Senate will help prioritize funding for our courts and the broader justice system in this next two-year budget. Also, Chief Justice Gilday wanted me to relay the message that she looks forward to working with all of you during the 2023 session. If you haven't met with her already, you can expect that she'll be meeting with you soon to discuss issues of mutual concern and the branch's budget request. The judicial branch's mission is to provide justice through a system that ensures equal access for the fair and timely resolution of cases and controversies. The importance of our work is reflected in Article 1, Section 8 of the Minnesota Constitution, which promises that every person in our state is entitled to access justice freely, promptly, and without delay. And the judicial officers and staff who serve in the judicial branch are tasked with upholding that promise. The Minnesota Judicial Branch comprises the three levels of state court in Minnesota: the state Supreme Court, the Court of Appeals, and 87 district courts. Our 322 judges and roughly 2,500 staff work in 103 different locations across the state, more than any other part of state government. Each year, roughly 1 million cases are filed in our district courts. It was a little higher than 1 million pre-pandemic, and it's been a little lower than 1 million during the pandemic. Our courts are funded almost entirely through legislative appropriation. All of the revenue we collect through court fines and fees is deposited in the state's general fund or to local government or other statutorily mandated programs. We don't retain any of that revenue. We depend on your appropriation to fund the vital work of our judiciary. Our current biennial budget for fiscal year 22-23 is approximately $768 million, which is equal to roughly 1.5% of our state general fund budget. So speaking of budget, I'll now turn our attention to our biennial budget request. The Minnesota Judicial Branch is proud to have maintained an open door to justice in Minnesota throughout the COVID-19 pandemic. By leveraging remote court hearings and nation-leading safety protocols, the Judicial Branch has ensured Minnesotans have always had a place to turn to seek justice, protect their rights, and peacefully resolve their disputes. As Minnesota emerges from this time of crisis, the Judicial Branch is using the lessons and experiences of the pandemic to modernize and improve how the judiciary serves the people of Minnesota. We now need the legislature's help to ensure that our courts can continue to deliver timely and effective access to justice, eliminate a lingering criminal case backlog stemming from the pandemic, and expand access to justice through remote hearings and other technological innovation. The single biggest challenge facing the Minnesota Judicial Branch is retaining and attracting a skilled workforce. To be clear, we recognize that the Judicial Branch is far from the only employer facing issues with employee recruitment and retention. However, the Judicial Branch compensation structure has fallen significantly behind other public sector employers in Minnesota, which is adding to our workforce challenges. For those of you who served on the committee last year, you'll recall that I shared similar concerns about our uncompetitive compensation structure in 2022. Our challenges since then have only grown worse, as the lack of an omnibus public safety bill last year meant our judicial officers and staff did not receive a salary increase in 2023. In fiscal year 22, we conducted a salary analysis comparing Judicial Branch salaries to public sector peers. From that analysis, we learned that the average wages for many Judicial Branch positions were 5 to 10% below wages for similar jobs in the public sector. We also know that many of our public sector peers provided salary increases of 5 to 7% for fiscal year 23, which means we have already fallen further behind from our fiscal year 22 analysis. To give you a clearer picture of what that looks like to our employees, here on the screen is a hypothetical salary progression of 2 employees hired at the same time. At the top is an employee hired in the executive branch of state government, and on the bottom, the judicial branch. While the 2 employees were hired at the same rate of pay, in just 4 years, the judicial branch employee is earning 12% less than the executive branch counterpart. That's a difference of about $5,500 per year in lower earnings. These next 2 slides highlight the challenges we are facing in employee recruitment and retention as a result of our uncompetitive compensation structure. Between 2018 and 2022, we've seen the share of employees leaving the judicial branch each year nearly double. In exit surveys with departing employees, the #1 reason employees gave for their decision to leave was salary. Meanwhile, the number of applicants for each open position with our courts has fallen dramatically. In 2019, we were receiving nearly 50 applicants for each vacancy. Today, we're only receiving an average of 13 applicants for each open position. Those numbers are even lower for more technical and skilled positions, such as in IT, where we have had several open positions receive 0 applications. I recently asked our judicial district administrators to describe the challenges they are facing in employee recruitment and retention. And here on the screen are just a handful of quotes taken from the pages and pages of feedback I received. One of the clear themes from these messages is that the courts are seeing judges and staff leaving the judicial branch to accept higher paying opportunities in city and county government and other parts of state government. And applicants are turning down positions because they are finding significantly higher pay with other employers. High turnover and extended vacancies are having a very real impact on how our courts serve the people of Minnesota. Our court administrators are being forced to postpone or delay scheduling of court hearings because of staffing shortages. Some are even considering closing some of their customer service windows. Because so much of our work right now is focused on addressing our criminal case backlog, our workforce issues are creating delays in other areas. Courts are reporting significant delays in housing court, family law cases, and other important matters. One court clerk recently reported that she was 6 weeks behind in entering marriage dissolutions into the case record. That means couples are waiting a month and a half after their final hearing to have the divorce officially entered into the court record. It's not hard to imagine the frustration and confusion that delay adds to an already difficult process. To put it simply, the workforce crisis in our courts is threatening our ability to provide timely access to justice for the people of Minnesota and really jeopardizing the people's trust and confidence in our judiciary. To address these workforce challenges, the judicial branch is seeking funding to increase judge compensation by 9% in fiscal year 24 and 6% in fiscal year 25, and provide a 9% compensation pool for employees in fiscal year 24 and 6% in fiscal year 25. In addition, as we always do in our biennial budget requests, we are seeking funding for the employer share of health insurance premium increases in each year of the biennium. By making our compensation structure more competitive, the legislature can help our courts continue to deliver timely access to justice and ensure that our courts can continue to recruit and retain the skilled and experienced workforce we need to drive innovation in our justice system and provide high-quality service to the people of Minnesota. Our next funding priority relates to one of the lingering impacts of the COVID-19 pandemic on our courts, a backlog of felony and gross misdemeanor cases in our district courts. As you can see on the screen, the number of felony and gross misdemeanor cases awaiting resolution in our district courts grew by nearly 40% between the start of the pandemic and late 2021. Most of that growth came from the first months of the pandemic, when the governor's stay-at-home order was in place and there was very little in-person activity happening in our courthouses. In November 2021, we implemented a statewide strategy to eliminate this backlog of major criminal cases. That strategy has been supported by federal pandemic relief funding, which has allowed us to use senior judges and temporary staff to hear and resolve additional cases. The good news is that the strategy is working. As of today, we have eliminated more than half, 54%, of the major criminal case backlog. However, the federal pandemic relief funding that we have been relying on to achieve this success will soon expire, and we are now asking for the legislature's help in addressing the remainder of the pandemic backlog. Our request seeks $8.4 million in one-time funding in fiscal year 24 to allow us to continue our successful backlog reduction efforts. We will use this funding to continue using senior judges and temporary staff to help eliminate the remainder of the pandemic backlog during the upcoming biennium. We also ask the legislature to help us sustain what may be our greatest success of the pandemic, which is the use of remote or online court hearings. Prior to the pandemic, remote or online court hearings were fairly rare in Minnesota. But during the pandemic, online hearings played a vital role in ensuring access to justice, as more than 80% of all district court hearings were held in online courtrooms. While our transition to the large-scale use of remote hearings was born out of necessity, it quickly became clear that the people we serve found real value in this method of delivering justice. In surveys and focus groups, litigants told us that they preferred remote hearings because they reduce travel time and costs and are easier to attend without taking as much time off from work or finding childcare. Attorneys and justice partners said that remote hearings worked better for many types of cases because they saved them time and money and led to more reliable scheduling and hearing start times. Civil legal aid said of remote hearings that it helped them more easily serve and represent clients all over the state. And victim advocate groups reported that victims feel safer and more empowered to participate in court hearings remotely. Given the success of remote hearings during the pandemic, the Minnesota Judicial Branch has made a long-term commitment to continue using remote hearings for many case types into the future. Early last year, the Minnesota Judicial Council adopted the One Court Minnesota Hearings Initiative policy, which sets out a statewide framework for how courts use both in-person and remote hearings to deliver access to justice. That policy took effect on June 6th, and we continue to hear positive feedback from court users about the ease and convenience of online court hearings. We have also heard accolades from other states who view Minnesota as a leader in the digital transformation of court operations. To support the long-term use of remote hearings, we are seeking $7.4 million in one-time funding to help us modernize our courtroom technology to better support remote and hybrid court hearings. This funding will also allow us to upgrade court interpreter equipment and capabilities and implement other needed technology enhancements in our courts. To close my presentation, I will cover three smaller funding items that are part of our budget request. The first is addressing the rising cost of providing mandated psychological services. The judicial branch is experiencing significant cost increases in this area. Over the past 3 years, the number of criminal psychological examinations ordered each year has increased by 28%, while the number of civil commitment examinations has grown by 48%. In total, the overall cost of providing these services grew by 58%. The judicial branch is seeking $1.996 million in annual funding to offset the increased cost of providing these statutorily mandated services. Our next request relates to treatment court programs, which is a term that encompasses programs such as drug courts, DWI courts, veterans courts, and similar programs. There are currently 4 treatment court programs across the state, which you can see here on the screen, that were established under federal grants that will soon expire. These valuable programs have proven to be successful, so we are seeking $422,000 in annual funding to add them to the state's treatment court funding formula and ensure they can continue serving their communities. The final part of our request relates to court interpreters. The 2021 legislature provided a one-time appropriation that allowed us to increase the hourly fees paid to contract court interpreters by 8% for the FY 22-23 biennium. But without permanent funding, those payment rate increases will expire this fiscal year. So we are seeking $200,000 in ongoing annual funding to permanently sustain that increase, beginning with the fiscal year 24-25 biennial budget. In total, the judicial branch is seeking $87.7 million in new permanent funding in fiscal year 24-25, an 11.22% increase over our base biennial budget. In addition, we are seeking $15.8 million in one-time funding in fiscal year 24 to address the backlog and technology needs I discussed earlier. Chair Latz, members, on behalf of the Minnesota Judicial Branch, thank you for your time and attention today and your consideration of this vital funding request for Minnesota's judiciary. We're extremely proud of the work we have done to maintain an open door to justice during the pandemic, and we look forward to working with each of you to address the challenges and opportunities our courts face as we emerge from this time of crisis. I want to again acknowledge the governor's support for this vital funding request and ask for your help in prioritizing justice system funding this legislative session. I'd be happy to answer any questions you may have about our funding requests or anything else about the judicial branch. Thank you.
Thank you, Mr. Shorba. We also have on our testifier list Dana Bartocci and Brett Richter, but I don't have a note of their affiliations. Are they affiliated with the court system, Mr. Shorba?
They are, Chair Latz. Brett Richter is in our finance division, and Dana Bartocci is our director of human resources. And they are here mostly to back me up in case I don't know something and need to answer questions. So,
all right. In the rare instance when you don't know the answer to a question, do any members have any questions for Mr. Shorba or any of the other judicial branch employees? Senator Limmer.
I do have a question, Mr. Shorba. A year or two ago, there was a little bit of a shortage in funds for translators in the court system. Has that been resolved, or is that part of your new proposal?
Mr. Shorba.
Mr. Chair, Senator Limmer, that is where the $200,000 comes in. That's the end part of our request. So you allocated extra money so we could give a raise to those contract interpreters, but it was one-time funding. So we're asking for that to be continued so we can continue to keep them at the level they need to be at. Thank you.
All right. Thank you.
For what it's worth, when a case needs an interpreter in the courthouse, they do get high priority, but there are often not enough interpreters available to meet the needs at any given time. So cases wait around, while interpreters are able to be found and brought into the courthouse. So it's a pretty fundamental requirement for them to be there. And of course, if someone needs an interpreter, they cannot participate in the justice system effectively because they don't speak the language of everyone else that's there. So very important to get this part funded.
Mr. Chairman,
Senator Limmer.
I had a constituent who was trying to get a real ID driver license, and she was born in Germany. She provided a German birth certificate, but because there was no interpreter, she has yet to get a real ID. And it's very difficult to find someone, for some reason, that can speak German that's a certified translator. And if Mr. Shorba would know anyone we could talk to, or maybe that's a motor vehicle problem, but I would think German would be a pretty common language in Minnesota. But maybe we've gone over that line. So if anyone knows that, I would certainly appreciate it. I know my constituent would appreciate the help that anyone could offer.
Mr. Chair, Senator Limmer, if you want to call Janet or have your staff call Janet, we can tell you who's on our certified list who speaks German, and maybe they could be available. So
that's great.
Happy to help out the Department of Motor Vehicles whenever I can.
All right.
Senator Cruin.
Thank you, Mr. Chair. I just wanted to make a couple comments on the in-person hearings. Somebody who practices in the state court system, not as much as I used to, there are definitely a lot of pros. I know in my volunteer work for the Children's Law Center, our 90-day review hearings, placement hearings are now all remote, and I can't tell you how better the system runs now than it used to, at least from a practitioner's standpoint, where it used to basically take a half a day, and out of my schedule now takes 15 to 20 minutes. And that's important if on these pro bono things, if it becomes too much of a burden, you're probably going to have fewer lawyers that step up to do that work. So that's a huge positive. I did hear from a constituent, though, on conciliation court that is still 100% remote. And I was just wondering if that's true. And is that the plan going forward?
Mr. Shorba.
Chair Latz, Senator Kroon, it is the plan right now. We are in sort of as I mentioned, our new sort of policy started last June 6th. So we are continuing to evaluate how it's going. So each situation, whether they're presumptively in person or presumptively remote, will be evaluated. We hope to have an evaluation completed around the end of the year so we can see how things are going. We've already made a few changes based on feedback that we've had over the last 8 months or so. But conciliation court right now is presumptively remote. Each judge can make an exception if they want to. For example, if there's somebody who does not have the right technology or some other limitation and they really need to come in person, if there's some big thing of evidence that's going to be presented, maybe that would be more conducive to in person. So they do have that flexibility, but conciliation for now would be presumptively remote.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Yeah, and I think there's probably mixed opinions on that, and I'm not having been in conciliation court in several years. I'm not, or experienced it at all remotely. I'm not sure I'm in the best position to comment, other than to share the constituents' concern that I think his opinion was, if it's an inherently adversarial hearing and somebody wants the option to show up in person, that they should have the option to show up in person, along with having a remote option as well. So I'm just passing along that view from my constituent. Thank you.
Senator Westland.
Thank you, Mr. Chair. Thank you, Mr. Shorba. So I practice exclusively in family law. And I can tell you that some of the sort of routine things, initial case management conferences and so forth, they may last 15 minutes. And so going remote and remaining certain things remote makes a lot of sense. It really provides accessibility, I think, for folks who then don't have to end up taking the equivalent of half a day off to show up for a 15-minute hearing. My feedback on that is I do think evidentiary hearings and trials, I think, are absolutely better in person. But I know that for family law, I think our efficiencies have been much, much better. I was at an ICMC this morning, so the efficiencies are much better. I do have a question for you, again, coming from sort of the lens of family law, in terms of resources for families coming in. And I think at this point, Hennepin County is probably the only county that has an in-house sort of court services where they can do social early neutral evaluations, custody evaluations, and so forth. And I think everybody else around the state, people have to find a private provider to do it, which creates two problems. There's an expense problem because private people are often far more expensive. And the second piece is there just aren't providers in many cases, especially in greater Minnesota. And so I don't know if the courts have considered any creative ways where those sorts of resources might be more widely available around the state of Minnesota. Most family law cases don't need a custody evaluation, but the ones that need a custody evaluation really need them. And I think it provides information necessary for a judge to make a good decision for a matter that's going to trial. So I'm just curious, that would involve an additional investment that I would fully support to make sure that people have access to the resources they need, especially around issues having to do with child custody.
Mr. Shorba.
Senator Latz, Senator Westland, you're right, there is some disparity there. Hennepin County provides a lot of services through their county funding that is not available in other counties across the state. We do have early neutral evaluation programs in other counties across the state, and ICMCs are taking place. But you're very correct. It's either using a private attorney or a pro bono attorney who agrees to do those kinds of services. It would have to be something that we possibly would need to discuss with the Association of Minnesota Counties and see if there's a way to share those resources in some way. But I do agree with you. It's certainly a valuable, very valuable resource if we could spread it out statewide. But right now, based on the county funding, we're not doing that. So I'm happy to talk with you more when we come see you, and maybe the chief and I will get some ideas from you about it. Thank you.
Senator Westland.
Thank you, Mr. Chair. Thank you, Mr. Shorba. I assume, like criminal law, family law matters are often so under-resourced, and it actually, I think something like 70% of people who appear are unrepresented, and it does create additional burdens on the court when we have under-resourced folks. And I would love to talk about maybe some creative things that we could do to try to help that situation.
Great.
And certainly this, along with other things, highlights the need for adequately funded civil legal services. Note from the presentation that they are able to represent more people more efficiently across the state because of the virtual technological capacity now for remote hearings. But they are still way understaffed in terms of ability to to serve the people, the number of people that would qualify for their services and ask for services, but they simply don't have the capacity to serve them. So I will be considering that to be a high priority in our budget as well. Anyone else on the committee have any questions or comments they'd like to make relating to judicial branch function or budget? All right, I don't see any. So any closer remarks or comments, Mr. Shorba?
Mr. Chair, we appreciate your time. This has always been a very welcoming committee, and we believe that our request is not only absolutely necessary, but very practical. So we tried to put together some one-time requests because obviously that helps out with the ongoing budget. But in order to function, we really do need some compensation this year that we weren't able to get last year. So I appreciate your consideration, and we'll see many of you in meetings in the upcoming weeks. And if there are any questions, feel free to reach out to me or my office. Thank you.
Thank you, Mr. Shorba. All right, members, we're going to move on to the next item on the agenda. Appropriately enough, it's Senate File 357. Senator Oumou Verbeten's bill relating to civil legal services appropriation. So we have before us now Senate File 357. Members, you did receive by email prior to the hearing the documents for the hearing. That includes the bills that are being brought up before us. So you can check your emails if you'd like to follow along with the text of the bills. Senator Oumou Verbeten, looks to me like you have a PowerPoint presentation and also an A2 amendment. Would you like to do your PowerPoint first, and then we'll go to the A2 amendment?
Thank you, Chair Latz. I will just give a brief introduction, and then I would like to hand the mic over to Dory Rappaport to give a presentation on civil legal services. So I think we can start with moving the author's amendment. It's just adjust the numbers. The bill as introduced had numbers from the previous year. And after we were able to get that updated amount from civil legal services, that's what's in the amendment. So I'd like to move the A2 amendment.
All right, members, Senator Oumou Verbeten moves the A2 amendment as her author's amendment. All those in favor? Here, we're going to have to do this. First time we're voting on our virtual hearing here. Please, members, turn on your video if you don't already have it on so that we can verify. And when you vote, give a visual indication of your vote as well, a thumbs up or something like that, or a hand wave when I ask for the ayes and nays. That way we'll have a appropriate record for perpetuity as to what we did as a committee. So on the A2 amendment, all those in favor signify by indicating aye.
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 All those opposed, motion prevails. The amendment's adopted. Senator Oumou Verbeten.
Thank you, Chair Latz. So I think this was a great introduction in talking about the courts and the resources that they need to support the public. A big piece of that is ensuring that folks have representation in civil legal services. Are nonprofits that are often referred to as legal aid. They provide legal representation in civil matters to folks across the state. So these are non-criminal matters like in housing and healthcare, employment, family law. They have 6 regional programs covering all 87 counties and 20 targeted programs. They serve Minnesotans up to 125% of the federal poverty guideline. That's about 37,500 for a family of 4. And their work improves the efficiency of our judicial system for all court users by making sure that people are represented by an attorney. And they've historically been underfunded, which affects, their ability to recruit and retain lawyers and provide these really crucial services. Something that I'll note is a set of other bills that you'll see come to Judiciary around tenant protections that I'm carrying. And in order for us to move forward on some of those reforms, we need to make sure that those folks have representation in our court. So this is very important to me. This appropriation would provide full funding to the civil legal services system to improve salary parity and eliminate the capacity gap over time to ensure all eligible Minnesotans can receive civil legal representation. And with that, I'd like to invite Dory Rappaport to give the presentation.
Ms. Rappaport, welcome to the Judiciary Committee. Go ahead and identify yourself and proceed.
Senator Latz. Hello, everybody. I'm Dory Rappaport. I'm the Executive Director of Legal Aid Service of Northeastern Minnesota. Is it okay if I share my screen?
Yes, please, go ahead.
Okay, just a moment. Can you confirm, let's see, that you can see the Seeking Justice for All?
Yes, I can.
Yes? Okay, great. Then I'll go ahead and begin. Thank you so much for the opportunity to speak today. I'm speaking on behalf of myself, but also the executive directors of the Minnesota Legal Services Coalition and all the organizations that are part of the makeup of civil legal services. You can see all the programs listed here, and they are 26 independent organizations who collaborate to create a statewide network of civil legal services in Minnesota. So we provide free civil legal services to low-income individuals in poverty law cases. So these are cases that impact people's safety, security, and stability in their lives. So we're helping people with legal matters surrounding their families, their housing, their safety and income and access to care, ability to live independently, their employment, and more. And we do this with through legal representation, coordinating legal clinics, providing legal advice and information. We create resources with easy to understand legal information, and we conduct outreach to help people identify that there is a legal remedy to the crises that they are experiencing. So to receive our services, as mentioned, individuals need to be at 125% of the federal poverty guidelines, but cases also need to be within our organization's priorities, and they must also be meritorious. The majority of civil legal services clients are from communities with disproportionately high poverty populations, such as in Black, Indigenous, people of color, people with disabilities, the elderly, LGBTQ+, and veterans. In 2021, civil legal services served 93,570 Minnesotans, which resulted in 43,762 closed cases. This was incredible considering the challenges that we all experienced in 2021. And for a system with under 500 FTE, this was quite the achievement, but also a reflection of innovation and dedication to service and successful partnerships. As you heard in Mr. Shorba's presentation with the court, we were able to conduct many of our cases virtually. But the reality is that despite the incredible work of civil legal services staff across the state, the system is not functioning to truly serve Minnesotans who need it. So there's really two primary problems. The first is compensation. The second is capacity. So we've worked on salary parity, but you can see here in this slide that despite improvements in the last 6 years, we are still at the bottom. We are still the lowest paid in the legal public sector. Law clerks have to take a pay cut to work at legal aid, where then they'll have clients and caseloads. And unfortunately, we're trailing behind our public defender counterparts by $15,000. We have to keep up, or we're going to lose any momentum that we've gained. And salary improvement has proven to make a difference in our turnover percentages. We used to have 32% turnover, but in the last 2 years, we worked really hard to improve staff salaries. Now we're down to 24%, but 24% is still too high. But we see that salary parity progress is key to attracting and retaining good staff. Okay, so after salary parity comes capacity, and we've touched on this. Of the people who learned that legal aid is a possible option for them, civil legal services can only provide services to 45% of those who are eligible. But that doesn't mean that people received all the services that they needed within that 45%, because only 28.6% are fully served. Because we have such limited staffing, we have to prioritize who we fully represent and who we don't. And those for staff are some of the worst decisions that they have to make. When we're asked what would it take to fully fund legal aid, we would look at what it would take to pay our staff competitive public sector wages, and then what it would take to increase our capacity to help significantly more Minnesotans in poverty. So this is a 6-year plan that aims to get salaries where they need to be and incrementally build capacity over time. So the red font here that you see under FY24 and FY25 reflects the Civil Legal Services change item request and what's currently included in the governor's budget. The rest of the numbers demonstrate what would be needed in the course of 6 years to achieve what we see as fully funded. The bill that's before you today can make that plan a reality. Sometimes it's hard to visualize what fully funded can look like, so we tried to do that for you here on this slide. So fully funded means that we would be able to fully serve priority cases, and then we could expand our priorities to do more types of cases that you see here. For example, more in tenants remedies, more in consumer law, more in employment law, more for access, medical access, and especially in family law, like we were just talking about as well. And we would then be able to expand our outreach to more rural and metro areas to help community members understand what civil legal services is, that the services are available to them. And we could do this through community-based services and continued investment in those technological improvements to increase access points to the justice system. This is really an opportunity to fix decades of underfunding. To invest in legal aid means dollars that ensure the fairness and functionality of the justice system, benefiting our state's economy, our housing crisis, the future and safety of children and families. Investing in legal aid is investing in interventions in the justice system. Invest less now instead of more later, and ensure that equal justice for all is reality in Minnesota. Thank you.
Thank you, Ms. Rappaport. I also have on our agenda here Ann Hefkin. Is she intending to present today as well, or was Ms. Rappaport's presentation on her behalf as well?
If for some reason I was unavailable, Ms. Hefkin had volunteered to present to the committee, and so she's watching, but no, she's not here.
All right. Well, I do have a question or two for you. You indicated that turnover was 24%. Maybe you already said this and I missed it, but is that per year?
That's correct. Chair Latz, that's correct.
So every year you're losing 24% of your legal staff right now. Is that correct?
Chair Latz, the 24% indicates the amount of turnover. And so we're losing, but then trying to hire. So just to frame it, we're staying within capacity. We'd have to look at some information to see how many organizations haven't been able to fill some of those positions, because that's certainly the case that there are openings that our partner organizations can't fill. But our overall rate of turnover per year for last year was 24%.
And then with regard to salary parity, is there a particular comparison group that you're targeting, or is it a more general analysis with a variety of comparison groups amalgamated?
So really, we're looking at the average starting salaries for staff attorneys in the public sector. So right now, as one of the slides demonstrated, we are looking at starting salaries for judicial branch law clerks and public defenders, but we also look at other public sector employees in the Attorney General's office, county attorneys, city attorneys. We're showing you in that slide the lowest starting salaries within the public sector. And so when I said we're at the bottom, we're truly at the bottom. That's what we're doing our comparison for. And we know this based on the information we get back from the people that unfortunately leave for higher paying positions. I hope that answers your question.
Yes, thank you. Any questions or comments from members of the committee? I don't see any yellow hands up on the screen at this time. Senator Oumou Verbeten, do you have anything else that you would like to add?
Just to thank Ms. Rappaport for the presentation, and I think you just laid out the importance of this work and why we need to fund it. So with that, I'd like to move Senate File 357 as amended to be laid over.
All right, actually, we don't need to have a formal motion to do that. I will simply lay the file over.
Right.
And for possible inclusion in our budget bill. So thank you, Ms. Rappaport. Thank you, Senator Oumou Verbeten, for the presentation. Senate File 357 is laid over. Members, next item on the agenda is Senate File 872. Senator Dibble is here. This is Youth Intervention Programs Appropriation. Senator Dibble, is this your first committee stop on this? I assume it is.
Yes, Mr. Chair.
We have an A1 amendment in front of us, so this would be an author's amendment. Can you just tell us briefly, since we're remotely, what the A1 amendment does?
Yes, thank you, Mr. Chair. The A1 amendment would require that a report be generated in March of each year, reporting to the legislature how these funds have been used. Who's received them, the geographic location, the number of individuals served, those kinds of things, so that we have a sense of the utilization of this appropriation.
Thank you. Senator Pappas has long advocated youth services in the Minnesota Senate. So Senator Pappas moves the adoption of the A1 amendment as an author's amendment. All those in favor, please indicate turn your videos on. All those in favor indicate aye.
Aye. Aye.
Those opposed? The amendment is adopted. Senator Dibble, your presentation, please. Did you want to make some remarks? And I see we have a number of people scheduled to testify as well.
Sure, I will try to be brief because the testifiers can speak more passionately and eloquently and articulately to youth intervention programs and what they do and why they're worthy of our state support. So thank you, Mr. Chair, for the opportunity to present Senate File 872. I'd also like to take the opportunity to thank my co-authors, yourself, Senator Latz, Senator Oumou Verbeten, Senator Kroon, Senator Lemmer. So youth intervention, what this would request would be to add $10.75 or $725 million per year in funding for youth intervention programs and establish a base level of funding. So that would be, Mr. Chair, a fairly substantial increase in the little bit north of $3 million that the state supports youth intervention programs throughout the state at present, a little over $7 million per biennium. But it is responsive, Mr. Chair, to the level of funding requests that come in every year for these community-based programs. What youth intervention programs are can be seen in statutes 299A.73, if anyone is curious about the program we've established that we fund. But these are community-based programs in organizations that are designed to reverse the growth of youth who are interfacing with our criminal justice and other public systems. It's a whole wide array of youth development, youth engagement, youth activity and opportunities, connecting youth to community and caring adults, and really helping them grow into healthy, productive, happy adults. Their programs address toxic stress, trauma, abuse. The data shows it's highly effective, that with adult support, these young people stabilize, they plan for their future, they stay out of trouble, they prepare for adulthood. And of course, the outcomes are extremely positive, very, very cost effective. I don't know if you have the information sheet in front of you, but by comparison, $2,000 or so that we might spend on a young person through intervention programs would be compared to over $75,000 if they were to be checked into residential treatment program, $56,000 into a group home, $40,000 if they're in a correctional facility, and so forth. There is a broad coalition of support. I hope you have all the letters of support in your packet. I would encourage you to glance through them, because that would also help everyone appreciate the broad and very diverse nature of the kinds of programming and services that are truly community embedded and community based that youth intervention programs support. So I should also add, part of this appropriation supports youth intervention programs association known as YIPA, which provides a lot of the essential infrastructure and training and support, very, very high quality, value added services that really strengthen the role and capacity and quality of these organizations, particularly those who are youth workers working on the front lines with these young people. And so a certain part of this appropriation goes to support that organization. And with that, Mr. Chair, I think I've exhausted what I'm able to say, and would toss the microphone, as it were, to Paul Munir, who's the Executive Director of YIPA.
Thank you, Senator Dibble. Mr. Munir, welcome back to the Senate Judiciary Committee. Go ahead and identify yourself and make your presentation, please.
Hi, Senator Latz. My name is Paul Munir. I'm the Executive Director of the Youth Intervention Programs Association. Senator Latz, if it's okay, we'd like to have our other two testifiers go first, and then I would go after them. So if it's okay with you, it would be great if we could have Stacy be our next testifier.
Sure. I see she has turned on her video. Is it Ms. Guilfoyle Collier? Did I say that correctly?
That is correct, Senator.
Thank you. Welcome to the committee. Go ahead and identify yourself, and you can go ahead with your presentation.
Thank you. Good afternoon, everyone. My name is Stacy Guilfoyle Collier. I'm the Executive Director of Youth and Family Services for the YMCA of the North. I lead a team of 80 phenomenal, amazing individuals that serve our 7-county metro area as youth support specialists, family support specialists, and education support specialists. We are helping young people that are at risk of or currently involved or exiting various different systems. I am also a board member of YIPA, as well as my programs receive funding from this grant. Statistically, how I introduced myself to you should not be my introduction. My introduction to you should wrap around possibly my substance abuse struggles, my criminal involvement records, or struggling to be able to meet my family's basic needs. But fortunately, that is not my introduction to you today. And that is all due to part of caring adults that came into my life at a very young age. In 1998, the Y was able to start an after-school pilot program that they got from New York City. And that definitely changed the trajectory of my life. I was able to get connected to caring adults at times when my needs were not being met. I was surrounded by violence and drug use, and I was definitely being shown a different way of life. These adults invested in me. They got me exposed to other programs and services, And despite any troubles I was experiencing, despite where I come from, they saw endless possibility in me. And due to that, my introduction to you today is what it is. And these individuals have remained connected to me to this very day. I call them, they give me advice, they have helped me stay on a positive path, and I consider them an extension of my family to this day. Now, what I do know is that sadly, not all of our young people are given this opportunity. Not all of our young people are given this valuable resource. My story should not be an anomaly. I should not be a one-off or a best case scenario. Fun fact, I have been testifying at the Capitol since I was 10 years old, asking and pleading for services to be increased, asking for services to not be cut, all in favor of my community, in favor of my peers, because I personally have seen my peers lose their lives to drug addiction, to incarceration, to the luring of negative influences. And I am few in my friend circle who have a different outcome. And that should not be the case. And so I'm asking you all to please invest in this. Please follow the recommendations that are put in this before you. I don't want to have to continue to plead and beg for services so that I don't have to continue to watch young people lose their lives that could be avoided through us investing in them. Thank you for your time today.
Thank you, Ms. Guilford-Collier. Mr. Munier, did you have another testifier you wanted to make a presentation?
Senator Latz, yes, please. Could Enzo go next? There he is.
Good afternoon.
Good afternoon, Mr. Chair. How are you?
I'm fine, thank you. Go ahead and state your full name and tell us what you'd like to say.
Hello, Mr. Chair and committee members. My name is Enzo Laos Calasara, and I attend Anoka High School. I am here to testify on behalf of young people in support for increased funding for the Youth Intervention Program grant. As a young person and speaking on behalf of my peers, we feel a constant and significant lack of support for our future and well-being as complete humans. Something needs to change, and I believe appropriately funding the YIP grant can be an important step. I can only speak to my experience as a student, but something I have noticed amidst many of my peers, myself included, is a feeling that the system doesn't care about us. For example, our school district recently held a vote on a spending bill in which 2 out of 3 provisions passed, except the provision that would have allowed for mental health resources to be supported and made available to students. Rather than trying to support our needs, the district's immediate solution to an increase in drug use and school violence was a massive increase in the amount of police officers at the school. This change has only led to an increase in hostility in the school environment and the perception that those in charge would rather put a Band-Aid on issues rather than address the root cause. Sexual harassment and physical assault are inescapable reality of high school for many, if not most, of my female friends. Suicide rates have increased at alarming rates. Issues such as school dropouts, truancy, youth experiencing homelessness, drugs, alcohol, fights, shootings, and students with firearms, and all of these and more are regrettably common issues that young people deal with today. All of this was worsened by COVID. A very close friend of mine took his own life at the age of 16. It certainly changed his life, and it impacted all those around him who loved him, including me. I don't like speaking about it, but I want you to know how real this is to me. His story is his own, but there are so many others like it. I can't help but wonder if he would have had support, if someone had cared more, if more had been done, would he still be alive? I don't want to lose another friend. I'm asking you to help us. The problems seem endless. It feels as if we are left to fend for ourselves. Young people are looking for support, but there is just not enough of it. The members of this committee can help change this. The problems facing young people are persistent, real, pressing, and dangerous. These are hard, difficult times. The longer we go without support, the scarier it gets. It becomes more likely that many young people will have their lives irreversibly changed as a result. Madam Chair, Mr. Chair, I believe Youth Intervention Programs grant can create change, and I'm certain it would mean a lot to so many young people. It will save lives. Please consider the impact you would have on those who so desperately need it and often never find it. Thank you. If you have questions, I'm happy to answer them.
Thank you, sir, for your testimony. Mr. Munir, how would you like to proceed with the presentation?
Thank you, Senator Latz, and thank you for allowing the testifiers to go in front of me. I appreciate that. I also appreciate the opportunity to testify on my own behalf, and I'll be very brief. It sounds like you have a super long day ahead of you. Extensive research shows that young people with external supports and internal strengths are prepared for good citizenship. The 2022 YIP outcome survey shows it works. 67% of young people reported that youth intervention helped them plan ahead and make good choices. 60% reported that it helped them take personal responsibility for their actions. And 57% say it gave them a positive role model in their life. The economic difference between a contributing member to society and a consumer of public services is staggering. YIP has commissioned 2 studies over the years to measure the economic effects of YIP. Research shows that youth intervention returns $9.78 for every $1 allocated. And it only takes 2.5% of young people to succeed for YIP to pay for itself over their lifetime. Youth intervention saves money to taxpayers. Minnesota has about 357,000 young people between the ages of 6 and 24 that are at risk of unhealthy development into adulthood. The current YIP allocation reaches roughly 8% of them. We need more youth intervention funding, and Senate File 872 will expand that to about 40% reach. In 2021, OJP issued a request for proposals, and the amount requested was 5 times greater than the amount available. Our organization, YIPA, has 156 organizational members that do not receive the YIP grant funding but are eligible for it. Chair Latz, since 1984, YIPA has been patiently explaining that if we don't pay attention to the young people growing up with toxic stress, trauma, and/or abuse, we'll all pay the price. And it seems to me that day has come. It seems like the general public and everybody is now seeing it. The well-being of our young people is not very good. We know that youth intervention works. We know it saves money, and we clearly know we need more of it. Thank you, and I'm happy to answer any questions you may have.
Thank you, Mr. Munir. I do have a question for you. The request here is for $10.7 million in each of the next 2 fiscal years. And then there's an expanded base appropriation noted as well. What is the possibility of making some of these appropriations one-time appropriations as opposed to putting it into the base? What would be the impact if it were treated that way?
Senator Latz.
Mr. Munir.
Certainly that would be helpful. But here's the problem. Consistency with the relationships to caring adults is the magic recipe for this stuff to work. Regardless if a program does mental health, park and recreations, mentoring, whatever, at the core of youth intervention is the ability for a caring adult in that community to build a trusting, lasting relationship with that young person. These are young people that have experienced a lot of trauma. One-time funding means that it will probably come and go. And that means young people will get connected, start building establishment relationships, develop a safe place to go after school, things like that. And if that money was taken away, we'd probably just consider it more trauma to that young person. Another example of what Enzo called, it seems like nobody cares. So it's hard for me to say, one-time funding wouldn't help, but in reality, it's not the right approach to take, I believe.
So, Mr. Munir, what you're saying then is that the funding would be used to pay salaries or costs of the adults who act as the caring adult and build those relationships with the kids?
Senator Latz.
Mr. Munir?
Generally, that's true. The average current grant right now is $43,000. The current grantees have been receiving that amount for about 12 years. At one point, we used to think that was enough to fund a staff person. It's not anymore. The statute says it could be up to $75,000. So I think these programs can use the funding any way they want, as long as it is when the work plan that they submit to OJP, it's justifiable expenses. But I think most of them use that to pay for personnel. The most expensive part of any organization or business is taking care of your people that do the work.
So, Mr. Munir, it's not just a matter of organizational staff facilitating a volunteer network of caring adults, but it's the organizational staff themselves acting as the caring adults. Mr.
Senator
Munir.
Latz.
Mr. Munir.
Great question. It's both. Sometimes a lot of our programs use volunteers as a way, which is what makes this so affordable. Generally, for every $1 million allocated, it can reach about 5,000 young people. Some programs rely on their staff to be those trusting relationships. Other programs go out and recruit volunteers and mentors, things like that. So it can be used in a variety of sort of ways. But it does take people to do it one way or another.
All right. Thank you. Any questions or comments from members of the committee?
Mr. Chair, I wanted to respond to your question quickly, if I may.
Yes, of course, Senator Dibble.
So, Mr. Chair, part of the way the current program is designed in statute and the way OJB handles the grant making is, I think currently the IPA grants support about 71 organizations, roughly, if I'm not mistaken, and that is looked to as ongoing stable funding for all the reasons that Mr. Miller just described. To provide allow these organizations to create the organizational capacity and competency, and then be able to rely on those funds. So new entrants, new grantees or awardees are eligible for funds when additional funds should become available through, a growth in appropriations made available by the legislature. And so while there are many worthwhile, highly competent and capable organizations, evidenced by the number of applications, evidenced by the number of member organizations in YIPA, there is a limitation. And I would strongly support maintaining that approach to this grant making because these are programs, not capital dollars. And so resources of a one-time nature means that an organization would ramp up and then organizationally would have to then scale back, which is extremely difficult for organizations to manage, plus the attendant consequence in lives that are not served.
Thank you. And I should note that as we're going into all of these budget discussions, we have a lot more one-time money available for our budget this year than we have ongoing appropriations. And so some appropriations requests are fairly evident whether they could fall into one bucket or the other. Not all of them are that clear. And so I want to make sure in this case we have a clear understanding of where the needs are and what kind of funding would be appropriate.
Yeah, I'm having the same considerations in my budget area too, so I totally understand.
Any other members of the committee have any questions or comments for Mr. Munir or any of the other testifiers? Senator Oumou Verbeten.
Thank you, Chair Latz. And thank you, Senator Dibble, for bringing this forward. Proud to co-author the legislation. I just wanted to point members to one of the letters that we received in support of this. It's titled the MAIC Youth Letter from a young person just sharing what these services mean to them. They're talking about having a safe space and being able to get out and enjoy nature and connect with people that have made them feel safe enough to do so. And it just, I think, it was said so well by our testifiers, right? That like when we invest in our young people on the front end, it really pays off in the long run. But I always love hearing from folks and seeing them write this letter and submit that to our committee. Just wanted to pay attention to it. So thank you so much for your work, and I'm proud to support it.
Thank you. And members, brings up a good reminder that the email that went out to all the committee members before the hearing started included all the supporting documents for the agenda items before us, including in this case, a long list of letters of support for this appropriation request. Anyone else have any comments or questions relating to Senate File 872? Not hearing or seeing any, Senate File 872 will be laid over for possible inclusion in our budget bill.
As amended?
As amended, yes, as amended.
All right, thank you, Mr. Chair, members. And just a final thought, do please glance at those letters if you can, even if you only have a few minutes. They're very, very inspiring. And there are only 13 of the 70-some organizations. Each one of those organizations could write a similar letter, or the young people who are connected to them. This is such crucial work. And a lot of what we've been reading about in newspapers, we would not be reading about if we really supported these programs and services. Thank you, Mr. Chair.
Thank you, Senator Dibble. Senate File 872 is, as amended, is laid on the table. Now, Senate File 1333. I'm the chief author on this bill. Senator Oumou Verbeten, do you want to run this portion of the meeting as vice chair of the committee?
Mr. Chair, yes, happy to do so. I'll let you begin your testimony.
Thank you. Members of the committee, Senate File 1333 is a Department of Corrections appropriation to expand the capacity and legal authority of the Fugitive Apprehension Unit. Their current jurisdiction is primarily related to arresting escapees and release violators. They do have general police powers during the course of official duties, but they have limited capacity, and there's some circumscriptions around those powers. So the bill makes clear that they have some expanded authority, and also gives them the availability and authority to respond to local law enforcement requests for support and assistance. It does remove some obsolete language in statute as well. We do have with us to testify today Mark Koderick, the Associate Director of the Office of Special Investigations at the Department of Corrections. At the conclusion of the presentation and questions, we'll be asking the committee to move the bill forward to the Senate floor.
Mark Koderick, you can begin.
Thank you, Senator. Thank you, Chair and members, for having me here today to speak in need of Senate File 1333 in our legislative framework. I apologize. I am Mark Koderick, the Assistant Director, Office of Special Investigations, Fugitive Apprehension Unit for the Department of Corrections. The Minnesota Department of Corrections Fugitive Apprehension Unit was created by the legislature in 2000. Minnesota Statute 241.025 Subdivision 1 gave the Commissioner of Corrections authority to have the DOC Fugitive Apprehension Unit officers perform duties necessary to make statewide arrests, but the authority of the agency is limited to arrest of DOC discretionary and statutory release violators, and DOC facility escapees. The unit is made up of 13 post-certified peace officers who are all highly trained in fugitive apprehensions and partner with local, county, state, and federal law enforcement partners daily to do its work. For your awareness, the governor's budget recommendation for the Department of Corrections includes funding to increase the investigations and staffing capacity of the fugitive unit, something I understand you will consider at a later time. In the bill before you today, Senate File 1333, DOC peace officers are authorized to carry out general law enforcement duties at the request of law enforcement agency of jurisdiction, investigate criminal offenses in agency-operated correctional facilities and surrounding property, and assist with other law enforcement agencies upon request. This bill also permits a local law enforcement agency to authorize our officers to assume the subsequent investigation of a crime should the primary jurisdiction so choose. The legal framework envisioned by this bill is similar to the statute used by Metro Transit officers. It grants our officers general law enforcement authority during the course of their duties as defined in statute and while assisting other law enforcement agencies. Currently, our unit is unable to assist or provide aid to local law enforcement jurisdictions in keeping our communities safe. There are three considerations relevant to this bill that I'd like to address today. First, this bill proposes that our officers may, on request, assist local law enforcement. By way of example, when we hear that a significant activity, like an active shooter, robbery in progress, hostage situation, or other officers on the street in a community requesting assistance has happened in a community, we currently cannot respond. This bill allows us to provide aid to local law enforcement to address a developing situation if requested. Second, this bill clarifies that officers have general law enforcement duties. DOC officers are always in the community while investigating individuals who have absconded. If a domestic call were to come in while we were conducting our investigation, even if the DOC officer's response time would result in quicker intervention, we are currently not able to assist local jurisdiction in this call. DOC officers are the only licensed police officers limited to a single purpose. Third, this bill makes sure that what happens in our facilities does not put a strain on local resources. When crimes are committed inside our facilities, such as violations of orders of protection, harassment by a person in custody, narcotics introduction, or assaults in Minnesota State Correctional Facilities, it can be very involved for local law enforcement agencies to investigate occurrences in these facilities, which of course impacts people in their communities and takes away law enforcement time from those communities. Officers are uniquely positioned to exercise law enforcement duties while investigating general cases in a way that can support local jurisdictions and thereby conserve their resources. I close by noting that officers, myself included, come from years of previous experience working as peace officers without restrictions to the statutes and laws taught to us through the licensing process. We come from departments such as Ramsey County Sheriff's Office, Maplewood Police Department, Wright County Sheriff's Office, Waseca Police Department, and Hennepin County Sheriff's Office, to name a few. By supporting this legislative change to bring the DOC's officers in line with other law enforcement officers in the state, you're allowing these talented, experienced veteran officers to work and contribute to an overall safer Minnesota community. Thank you for your time.
Thank you, Mr. Kodrick. Members, do you have questions? Senator Limmer.
Yes, I had a quick question. Does the appropriation that they're requesting include more officers this year?
Senator Latz.
Let's see, the bill we have in front of us does not include an appropriation specifically. It's dealing with the statutory authority. I guess I'd have to ask Mr. Kodrick if he has any specific information on the budget request, or Mr. Turner can answer the question for us.
Mr. Chairman.
Mr. Turner.
Madam Chair, members, the governor is requesting $1.865 million per year for the Fugitive Apprehension Office. It's 10 new positions.
Mr. Turner, do you know, Madam Chair, Mr. Turner, do you know what the complement of the present officers are in this area? Or perhaps I should ask our representative of the fugitive task force there.
Madam Chair, Commissioner Schnell is also available to answer questions.
Commissioner Schnell?
Madam Chair, thank you. Senator Limmer, right now, the unit has 13 agents. There would be, this does call for, but the budget side of this, which would be separate, does include expansion of that unit. We want to make sure we're keeping the number of fugitives warrants as low as possible.
So, Madam Chair, Commissioner, is there an increase in escaped fugitives that would justify nearly doubling the complement of the staff?
Commissioner Schnell?
Madam Chair, Senator Limmer, yes. Right now, we've been running approximately the numbers of people at any given time who are subject to a supervised release warrant across our state has been somewhere between 420 and about 520. But this is more than double what we saw in the historic past. And some of this just relates to the fact that, we are, the unit has been substantively focused on higher risk cases. Those would be loss of life cases, and level 3 sex offenders have been really the priority of the unit. But obviously, as we look to address issues around repeat offending, making sure that we're keeping this number low becomes very important, which is why you see the expansion in the number of agents being requested.
Senator Limmer?
Madam Chair, I know our previous discussion was always about the authority of the unit as it interacted with local law enforcement. I don't remember an increase of this size even being discussed. It seems like it's a little, at least to me, it seems like a surprise. But to jump up so fast in one appropriation budget.
Commissioner Schnell?
Madam Chair, thank you, Senator Limmer. The language around authority is the language that we had developed in concert and connection with you previously. That relates to authority. The budget discussion, which will be coming forward with the governor's budget recommendation that the committee will discuss, does include that expansion of the unit. I think we will definitely be able to show those numbers and the importance of this. And I think it's also being responsive and reflective of the fact that there has been increased concern across the state about repeat offending. And if we're talking about people who are on supervised release supervision that now are subject to an arrest warrant, obviously the state's public safety benefits from ensuring that these people are brought into custody and that the violation behavior is addressed as quickly as possible.
Senator Limmer, do you have any follow-up?
Well, I just find it curious that it seems we get mixed messages. We hear that certain people in Department of Corrections wants to have less probation terms, but at the same time, that there's an increase in repeat violators. So I don't want to belabor the subject right now, but it is something that I think we should discuss in the near future. Thank you.
Thank you, Senator Limmer. Senator Westland?
So just for clarity, to make sure I'm tracking this, my understanding of what this bill does is we have the Fugitive Apprehension Unit, which currently has a specific scope of authority, and that is to make arrests statewide for release violators and facility escapees. My understanding is what this bill does is expands that authority so that the unit can assist local law enforcement when it's needed. And so my understanding then is we're expanding the scope of authority. So the request that goes along with that is that we have more personnel. Do I have that right?
Commissioner Shell?
Madam Chair, I think you are correct as it relates to authority. Essentially, what we want to make sure of is really, I think there's two ways of explaining this. Today, what happens is that if the Fugitive Apprehension Unit officers make an arrest of somebody who is subject to that supervised release warrant, and let's say, for instance, that at the time of that arrest, they are in possession of a firearm or something like that, a new criminal activity, technically what has to happen is that that really should be turned over. That new criminal activity gets turned over to the local law enforcement agency. And this can create a burden for them that oftentimes, just coming from law enforcement myself, it was always this notion of if you take this activity, you uncover something, you handle that investigation, you submit it to the local county attorney. We advise the local law enforcement agency. What this does is it grants the authority for DOC officers, police officers, these are regular sworn peace officers, to be able to carry out those investigations, obviously let the locals know, and if they want to take it, they can. In most instances, they would prefer that the people who initiated that new investigation, that new activity, that they handle that and get it referred to the county attorney. And then the second thing, as Assistant Director Kodrick mentioned, the last thing we want to do is be in a place where as a state, we have state licensed peace officers. These are peace officers that have authority. And should something be occurring, and they're there, we want them to be able to assist that local agency. It's very difficult if you had a situation, and we have, where officers just happen to be doing their fugitive activities and we're nearby an incident, but really their authority is limited to be able to even assist that agency. And so this really grants them the authority, to work with the local agencies to assist. And that's really what the essence of this bill focuses on. The budget appropriation is really separate to really looking at the numbers of warrants that we have and the desire to keep that number as low as possible, which we believe will support public safety.
And Madam Chair.
Yes, Senator Westland.
Thank you, Madam Chair. And just one additional follow-up. I believe I heard you say that the sort of the caseload, if you will, of either release violators or facility escapees, I think you said it was somewhere in that 400 to 500 number. And just to put that in perspective, can you tell us how many that is in relation to, like, what is the larger number of people who are on release? Like, so what proportion of those folks are you dealing with in relation to the larger number?
Commissioner Shell?
Madam Chair, Senator Westland, at any given time, there's about 7,500 people on supervised release, plus or minus. When we talk about escapees, we're talking about, the majority of these people are release violators. They've kind of not kept in contact with their agent. They may have engaged in we learn about the fact that they've engaged in some new criminal activity. And so that's really what we're focused on in this population. And again, I think there is not a distinction between the desire of having people do well, and the majority of them do, but making sure that when there are those occasions, that small number of the whole population that are subject to a warrant, we want to make sure that we're bringing them in and addressing that as quickly as possible.
Madam Chair, just
Senator
one or two follow-ups. And so my quick back of the envelope math was, if we have 500 people that you're kind of interacting with out of 7,500, that's about 7% of the total population. And my understanding is you're that there's a significant focus on sex offenders, high-level sex offenders, and in instances where there was loss of life crime. Is that correct?
That is correct.
Michelle?
Sorry, Madam Chair. Yes, that is correct. We do. Those are the primary focuses. Now we have other, obviously as time allows, they focus on others. And those are the cases that we're concerned about. Some of the people who may be engaged in ongoing criminal activity. We want to be able to work with local agencies to get those people into custody as quickly as possible.
Senator Westland?
Just thank you both to Mr. Koderick and Commissioner Schnell for clarifying these and bringing this information to us today. Thank you.
Members, do you have other questions? I just have one question. Are there other states that are granting their corrections department or specific unit this authority?
Madam Chair, yes, there are other states that do have sworn police officers. And I think that's one of the key distinctions here is that these would be regular Minnesota licensed peace officers. And it really is their core focus and this unit's core focus is on addressing and following up on and investigating these cases of people who are subject to a supervised a warrant that's been issued by the Department of Corrections because they are non-compliant and bringing them in. So yes, it is something that is a focus, and I think when it was established here, it was a desire to make sure that while local law enforcement agencies do a good amount of work in this area as well, putting that burden on top of them can take away from regular responses in their communities, and that's why this unit does become important as a resource to address this particular focus of people who may be subject to these warrants.
Thank you, Commissioner. Any other questions? All right, Senator Latz, do you have any final comments? Would you like to move the bill?
Well, I'd ask for the committee's support. I move that Senate file number 1333 be recommended to pass and be sent to the Senate floor.
I saw you take your mic off, Senator Limmer. Did you have any questions?
No, I'm just ready.
Okay. Great. Senator Latz has moved Senate file 1333 be recommended to pass and to the Senate floor. All those in favor, signify aye, raising your hand.
Aye.
Aye. Opposed? All right, the motion passes. And the next item on our agenda is also your bill, Senator Latz, Senate file 1450. Whenever you're ready.
Thank you, Madam Chair. I'm going to pull that bill up on my screen from our materials as well. Madam Chair, this bill would establish a mental health unit pilot program for individuals with mental illness and who are incarcerated in jails, and it would require a report as well. This is brought to us with the support of the county attorneys, the sheriffs and the Commissioner of Corrections. We've all heard the stories about how a substantial portion of incarcerated individuals are suffering from mental health issues. It's fair to say that our system of incarceration in Minnesota, it's accurate to say that our system of incarceration in Minnesota is the largest institution, if all considered together, housing people with mental illness in the state. So it's incumbent upon us to treat these individuals, handle them appropriately while they are incarcerated. And to do so, we're trying to figure out the best way to do it. This would establish a pilot program to test some of those ideas. It's been developed, as I say, by sheriffs and the Department of Corrections. And I have with us today Renville County Sheriff Hable and Commissioner of Corrections Schnell to provide testimony in support of this initiative.
Struggling to unmute there. Thank you, Senator Latz. Who would you like to testify first?
We could have.
Thank you, Madam Chair. I would just give some of the background, and the sheriff will be really beneficial to kind of wrap up the need and the significance of this ask. As again, I'm here in support of Senate File 1450 as the Commissioner of Corrections. Over the past several years, we have heard from our partner county sheriffs and jail staff across the state who face really significant challenge in finding treatment for people who are incarcerated, who have serious and persistent and chronic mental illnesses. In working with the with the Sheriff's Association, the DOC has put together a policy proposal to provide an avenue to study how the state and the sheriffs could partner to address some of the challenges that we face. The bill before you, Senate File 1450, creates a pilot program that would allow county jails and sheriffs to contract with the DOC to house and treat individuals that are currently being held in county facilities who have these serious and persistent mental illnesses. Under the pilot, inmates would be transferred from the county jails and instead be housed and treated at the secure mental health unit at the Department of Corrections Oak Park Heights facility. That facility has a staffed mental health unit that has people who are specialists in this mental health area. It operates very similar to what you might see in a secure hospital setting with mental health providers across the spectrum, psychologists, psychiatrists, and nurses as well. This pilot would be limited to 5 individuals who would be placed by the counties at the DOC's mental health unit. The DOC, we do believe we do have the capacity at this time to provide services to these individuals, and under the language, this would be budget neutral for the state, as the county would be paying the per diem and additional expenses that may occur. And now I want to be clear that this is not a situation where we're just charging the county for this. The counties would in many cases already need to purchase or procure these services in their communities. And in some instances, that can become very difficult. Transportation costs to travel large distances to get people to needed services does become a challenge. Just as recently, we worked with one of the counties who had a man who had been adjudicated so that he had been found guilty, but there was some issues that he had, and the jail could no longer provide safe services for him. He had assaulted a number of staff. He had been taken to the hospital a number of times and assaulted medical providers in the local emergency department. And the sheriff requested. Now, the difference there was that person was had already been found guilty and was pending sentencing. So there is an opportunity for an interim order for commitment that the court could impose. And that's exactly what happened in that particular case. And this pilot, the Department of Human Services, the DOC's Health Services staff, and today with us is Assistant Commissioner Nan Larson, who oversees all of our health services, including the mental health, behavioral health side. The Sheriff's Association and NAMI would be involved in overseeing and evaluating this project. The program is time limited and was result in a report to the legislature that would outline the program's benefits, challenges, and any recommendations that might come forward in the future. We're thankful to you, Chair Latz, for being willing to carry this bill. I'd be happy to answer any questions after the sheriff testifies, if you'd like. Thank you, Madam Chair.
Thank you, Commissioner. Sheriff Scott Dibble, if you could begin by saying your name and title and then commence with your testimony.
Thank you. Good morning, Madam Chair, members of the committee. My name is Scott Dibble. I'm the sheriff in Renville County, and I also represent the Minnesota Sheriff's Association today, where I serve on their executive committee and am a co-chair of the Jail Policy and Oversight Committee. Senator Latz, you really took the words out of my mouth. These jails across our state have really become warehouses for the mentally ill. We're doing the best we can. Unfortunately, we're not doing a very good job, only because we don't have the resources. So you're right. It's incumbent on us to to provide the treatment to these folks with mental illnesses, just like we provide treatment to our inmates who have physical ailments and injuries. But again, unfortunately, these folks in our care and custody tend to deteriorate rather than get better. And they are so incredibly taxing on our correction staff. So many of these inmates require one-on-one supervision. They require undivided attention of our staff. And unfortunately, we just don't have the staff to do that. Earlier this week, I shared a story with your colleagues over in the House, and I think it's worth repeating again today. It's a story of a young lady who we call Jane. It's a true story. She's 25 years old. To look at her, she's a very nice looking young lady. You would never know that she struggled with mental illness. However, she has a very, very long mental health history and is no stranger to our jail. So about 4 o'clock in the afternoon on a Sunday, one of the custodians at one of our Catholic churches here in the county went to the church to lock the doors for the day. And inside, he got to the sanctuary and he noticed that it was in complete disarray. Their beautiful statues had been toppled and were broken. There was glass everywhere, papers everywhere, books thrown around. It was destroyed. And so there in the front of the church was a young lady who we're talking about. We called her Jane. And so Jane was busy tearing up the carpet in the church, putting it on this pile that she had started to create in the aisle leading up to the altar where she had tried to light it on fire. So there's books and hymnals and Bibles and so forth all piled up, and she tried to light it on fire. There's more to this story, but eventually Jane landed in our jail where things again got worse instead of better. So these bizarre behaviors continued. She clearly was not reality-based. She demanded the number to the White House so that she could talk to her staff. She was delusional. She was seeing things and hearing things that weren't real. Most of her day, she sat in her cell and talked to herself or cried or screamed or pushed that call button hundreds of times, trying to summon the corrections officers to be with her. She was literally crying out for help. At one point, she was begging to be taken to the hospital so the doctor could, in her words, fix her head. And unfortunately, there wasn't anything we could do for her. At one point, she tried to harm herself. She had managed to wrestle a key away from one of our correction staff, and that's what she used as her own weapon. At one point, she removed the very clothes that she was wearing, stuffed them in the toilet, and began to flush that toilet over and over, trying to flood her cell to get the demons out of her cell. She was convinced that in 2018, the then president forged her signature onto the Bill of Rights. Jane's story goes on and on and on, and you've heard them before. She so badly needed mental health treatment, but unfortunately, there wasn't a thing that we could do with her in our jail because, again, we don't have those resources. Remember, we're talking about corrections officers. That's who's caring for these inmates. I take nothing away from them, but lots of them have just a high school education, yet they're charged with being responsible for and caring for perhaps the most complex humans on the planet. What do you think is going to go wrong here? It's just not a great setting. So remember, though, this happened in our jail. We have a 72-bed jail. It's a medium-sized jail in the state, and we have dedicated corrections officers. Imagine if this story would have played out in a small county or a smaller county with a small county jail. So many jails across the state today are not staffed with just corrections officers. Instead, they have dispatcher jailers. So one person responsible for the 911 center, answering 911 calls, dispatching emergency services, and caring for the inmates. And so unfortunately, in a scenario like Jane's, there's virtually no way that they could have kept her safe. Again, this is just one of so many stories across the state. Our jails just aren't the correct place for these folks with serious and persistent mental illnesses because we can't care for them. So this bill, I know isn't probably the end all solve all, but it's absolutely a step in the right direction. It creates a bit of hope that we might be onto something. It's only a pilot program, which means if it fails, no harm. no foul. We're out nothing. However, if it succeeds, it could show that we're onto something, and this could be a game changer. We just don't know until we try, right? We've heard that so many times. So again, if this is the case where it is successful, everybody wins, not the least of which is Jane and others like her. So I won't take any more of your time. Again, it's my honor to be with you today. And of course, I'll stand for any questions that you or the committee have.
Thank you, Sheriff Abel. And members, I know we're getting close to 1, but I think we can continue on and see what questions or comments you have for Senator Latz or the testifiers. Okay, well, hearing none, Senator Latz, any remaining comments? Would you like to move the bill?
Yes, thank you, Madam Chair. You will note these are people who have serious mental illnesses and who need to be in secure facilities. And that's a tough combination. They should at least be in facilities where the personnel watching over them, taking care of them, have the training, the capacity, the expertise, the knowledge, the experience to do so safely and humanely. We in Minnesota have a shortage in the mental health system of secure facilities for those who have not run afoul of the law, but who need to be in more restrictive care settings. But for those who have run afoul of the law, it's kind of a dual law enforcement and mental health concern. And what is proposed here, I think, is a very helpful, what we hope will be a very helpful way to address these multi-problems. So with that.
Senator Latz, I think we have just a few questions now. So I'm going to go to
Okay.
Pappas.
Thank you, Madam Chair and Senator Latz. I just had a question for the commissioner about a secure mental health facility for women is there one at Shakopee? Because Sheriff Habel's example was really about a woman, and I assume that you're not putting women at Oak Park Heights. So is there also an option somewhere else in the system for women?
Commissioner Snell.
Madam Chair, we do have some ability. Oak Park Heights is a unique facility in the sense that there are ways to do separation of by sight and sound, so that we could, in fact, address some of those issues in that unit, and still maintain compliance with those separation requirements. So those are things that are possible within the MHU.
Okay, thank you.
Senator Pappas. Thank you. Senator Limmer.
Thank you. Having worked in the corrections field for a few years, way back in my early days, I know that the mental health issue is a real one, and it seems to land in our jails, workhouses, and prisons. It's unfortunate that the state, when they started to get rid of larger institutions that could handle some of these things and handle the scale that's necessary, they didn't replace it with too many alternatives. And so everything kind of fell into the corrections system or local hospitals, but local hospitals aren't really equipped to handle that either. So a pilot program, I think, is a reasonable step to move forward, to analyze a little bit. And it's something that I would support. Thank you.
Thank you, Senator Limmer. Any additional comments or questions? Okay, Senator Latz.
Madam Chair, I move that Senate file number 1450 be recommended to pass and be referred to the Senate floor.
Senator Latz recommends that or moves that Senate file 1450 be recommended to pass and referred to the floor. All those in favor signify aye. Raise your hand.
Aye.
Aye.
Any opposed? All right, the motion passes. Now, I think it's
Can I
time
make
for us to take a break.
Can I
Go
make
ahead,
a
Senator Westland.
suggestion? I think we have one bill left.
Senator Latz, I'm giving the chair mic back to you to make the decision.
If that is actually correct, Mr. Chair, I would suggest we push through and get this last one done and then be done for the day.
Madam Chair, well, sorry, I'm the chair now. Senator Westland, we do have Senate File 1819, but we also have a committee discussion relating to supervision programs with the Department of Corrections, the Association of Metropolitan Counties, Minnesota Association of Community Correction staff as well.
Sorry, Mr. Chair.
So we do, yeah. And I recognize we've been going about 2 hours now without a break, at least for some of us without a break. So I'm just going to, what we're going to do is we're going to take a 15-minute recess so people can take care of whatever they need to for 15 minutes, and then we will reconvene and complete our agenda for the day. My computer shows 1:02, so members, please plan to reconvene at 1:17. The Judiciary Committee is in recess. The Senate Judiciary Committee will come back to order. Next item on our agenda is Senate File 1819, Senator Pappas, Juvenile Risk Assessments Authorization.
Thank you, Ms.
Pappas. We also have an A1 amendment in our packets. This is your first stop. Is this an author's amendment for you?
Mr. Chairman, oh yes, I remember this amendment now. Yes, this is an author's amendment.
All right.
Basically restructures the bill so it flows a little better.
All right, Senator Pappas moves the A1 amendment as an author's amendment. Members, please turn on your videos, and all those in favor say aye.
Aye.
Aye. Opposed? The motion prevails. The amendment is adopted. Senator Pappas, to your bill.
Thank you, Mr. Chairman and members. This bill requires juvenile detention facilities to use an objective and racially, ethnically, and gender responsive risk assessment instrument to determine whether children who aren't released to their parents or guardian should be detained in a secure facility or placed in a non-custodial community-based supervision setting. The instrument must be developed by the Department of Corrections and county courts or judicial districts in consultation with the Minnesota Juvenile Detention Alternative Initiative. The instrument must assess the likelihood that a child released from detention would endanger others or not return for a court hearing, and must identify the appropriate community-based supervision that would be best for the child and public safety. The risk assessment tool must also identify the type of community-based supervision that would be best for the child and public safety. And this is a Department of Corrections initiative, and I have with me Deputy Commissioner Curtis Shanklin.
Mr. Shanklin, welcome back. Commissioner Shanklin, welcome back to the committee. Please go ahead.
Chair Latz. Can I proceed?
Yes, please do.
Good afternoon, Chair Latz and members of the committee. Thank you for the opportunity to be here today. And a sincere thank you to Senator Pappas for bringing this bill forward, along with all your continued support throughout the years for our Minnesota youth. I also just again want to thank Chair Latz and Senator Limmer too as well for all your continued support for our youth across our 87 counties here in Minnesota. As mentioned, my name is Curtis Shanklin, and I am here today representing the Minnesota Department of Corrections, where I have the distinct honor to serve as Deputy Commissioner overseeing the Reintegration and Restorative Services Division. As I proceed through my testimony, which will be brief, I implore each of you to think about this bill through what we call the My Child test. If you're a daughter or son, granddaughter or grandson, or maybe even niece or nephew, had contact with the juvenile justice system that would warrant potentially being secure in a detention facility, how would you want their experience to be? An analysis of both local and statewide data regarding arrests in Minnesota have revealed glaring inconsistencies that stretch across our 87 county lines. And despite the best efforts of our courageous women and men in law enforcement, we have found that there is subjective, unnecessary, and at times inappropriate detainment of Minnesota youth who are low risk and do not pose a threat to public safety. This was the case more than 20 years ago here in Minnesota, along with an overcrowding of our secure detention centers that led Minnesota, with the assistance of the Annie E. Casey Foundation, to adopt the Juvenile Detention Alternative Initiative model, a model that has been the most successful juvenile justice reform effort to date nationally, as well as here in Minnesota. Through the leadership of Minnesota JDAI and communities across the state, we were able to safely reduce our juvenile detention center numbers by close to 80% at its highest point, and did so without compromising public safety and while saving Minnesota taxpayers millions of dollars. A central component to this success and the precipitous drop in local detention numbers was the adopting and use of a statewide risk assessment instrument, also known as ARRAY, in our JDAI sites. Senate File 1819 is a bill that would require secure detention facilities in the state of Minnesota to use an objective and racially, ethnically, and gender responsive juvenile detention risk assessment instrument, also known as ARRAY, to inform detention decisions. Under the Juvenile Detention Alternative Initiative, also known as JDAI, many secure detention facilities, both in the state of Minnesota as well as nationally, already use this tool. The ARRAY is specific to the 36-hour window from the time of potential detention admission to the required court hearing, and is specific to assess the youth's risk to reoffend prior to court or their ability to not appear for their court hearing. Lastly, I will point out that in some states, like Wisconsin, the use of one tool is required for the entire state, regardless of location. And listening to our local stakeholders and understand the differences in locations of our secure detention facilities across the 87 counties here in Minnesota, we are asking that secure detention facilities use a model of the ARRAY and tailor it to their local jurisdiction. This will allow local jurisdictions to tailor the tool and for stakeholders to be involved in the creation and implementation of their tool. Before I close, I will also just point out, after listening to the prior testimony and Sheriff Habel and Commissioner Schnell and Chair Latz and others talk about the deficiency of resources as it pertains to how do we address the needs of our adults with mental health and how many of them end up in our local jails. Unfortunately, that is true for our youth too as well. Because of this deficiency in mental health resources, our detention facilities often are the place where many of these youth end up, with not the resources and at times the staff to meet their needs. I think it is important for us, particularly what I consider our most vulnerable, complex, but also our most thriving population, our youth that have the most potential, that we are ensuring that those youth who we do take into secure detention are those who absolutely need to be there, and that we are creating options for others, because we do know that once a youth is introduced into secure detention, the likelihood of them committing a more significant offense increases by upwards of 60%. And with that, I will conclude my testimony, and I will stand for any questions that any committee members may have. Thank you.
Thank you, Assistant Commissioner Shanklin. Are there any questions or comments from members of the committee? Senator Pappas, is there anyone else? I don't have anyone else on my list of testifiers. Is there anyone else that you wished to have testify in connection with us?
I don't have anyone else, Mr. Chairman.
All right. Then,
so, Mr. Chairman, at the beginning of our meeting, we discussed creating kind of an omnibus juvenile justice bill. I do have two other provisions that are coming before this committee. one was pulled from the agenda today because it's still being negotiated. There's one other, I don't know if other members have any out there, but just to kind of be more efficient in terms of activities on the floor, that's my recommendation. And we talked about holding this over then until those other bills are presented to the committee.
Senator Pappas, I think that's a wise course of action. And so not seeing any further discussion or questions at this time, we're going to lay Senate File 1819 as amended on the table. And we'll move on to the next item on our agenda.
Thank you very much, Mr. Chairman.
So members, the next item on our agenda is a discussion of community supervision programs. We have a robust list of presenters to give us information on this, to inform our discussion. And so I think we're going to be starting with Carly Stark, if I understand it correctly. I also see Commissioner Schnell is on the agenda. So you guys should let me know if I'm going in the right order, and then we can go into some of the others that I have on the list. Ms. Stark or Commissioner Schnell, who's going to start?
I believe I am going to start unless something's changed.
All right, Ms. Stark, go ahead and identify yourself for the record then and proceed with your presentation.
All right, thank you, Mr. Chair, members of the committee. I am Carly Stark. I am the Public Safety Policy Analyst with the Association of Minnesota Counties. We are an association that represents all 87 counties in the state of Minnesota, and normally you would be hearing from commissioners, but due to the weather and a conference that we turned virtual at the last minute, that just didn't come together in time. So you're stuck with me. So I'm going to share my screen because I do have a presentation. All right, so supervision in Minnesota. There we go. So Minnesota is kind of a unique state when it comes to community supervision. We have 3 different ways that community supervision is delivered. So we have Community Corrections Act, where the county does all of those supervision services. We have County Probation Officer, where there's sort of a combination of county and state. The county does the juveniles and the adult misdemeanors, and then the state does the supervision of people who are charged with a felony. And then there are counties who contract with the state to do the misdemeanor services and the felonies. So then it's state employees are doing that work. So one thing I will say is that as I go through this presentation, when I say community supervision, it's kind of an all-encompassing term that includes probation, supervised release, and intensive supervised release. So between the 3 delivery systems, we work together as one supervision system. There are the very similar goals for all 3 systems. Community Corrections Act has the most number of cases, with about 70% of the probation and supervised release cases. Department of Corrections is about 20% of the probation and supervised release cases, and county probation officer counties have about 10% of the probation cases. Counties get to choose which of the 3 delivery systems works best for their local community. In some communities, it makes more sense for the state to provide the services, and in others, it does not. The choice is local and it's collaborative, and it's what makes Minnesota unique. So the funding is different for all 3 systems. So for DOC counties are billed for the service costs of juvenile and misdemeanor services, including agent salary and fringe benefits. But then counties are reimbursed for a portion of these costs with funds that are appropriated by the state legislature under the CPO reimbursement model. So the way that works in practice is the DOC has a budget request in the governor's budget, and they request the funds that they need to provide supervision. Felony supervision and intensive supervised release is paid for by the state. In CPO counties, as I mentioned, the county does the misdemeanor supervision and the state does the felony. Those counties are also eligible for a 50% up to a 50% reimbursement of certain salary and benefit costs. One of the provisions does say that if the legislature doesn't provide enough funding, that 50% shall be prorated. Right now, the state funds cover about 27% of those costs. In those counties, felony supervision and intensive supervised release are paid for by the state. Now in CCA counties, it gets really complicated. So there is a state subsidy that flows through the Department of Corrections because the county does all of the supervision services. The formula is the primary source of state funding, and it's basically a complicated formula that includes case filings, population, people who are convicted of a felony but not sent to prison, and then adjusted net tax capacity. It uses 3-year averages, and the state funding for that is significantly less than 50%. Based on a very rough data collection that I did a few years ago, I think the average was probably around 30%, but it's a bit harder to figure out the county versus state share of that funding model because it's just not as clear cut as with the CPO. But over the years, the 3 systems have been forced to compete for resources because of all the differences in funding. So we've come to the legislature all asking for a share of the same money, which does not serve the citizens of Minnesota. We all serve the same people, Minnesotans, and we all have the same goal, which is community safety, which is why together we've all come together to try and figure out a better way to fund community supervision. So you've heard this already in committee a few times, but Minnesota relies heavily on community supervision. These numbers are from 2019 because that was the last year before, the pandemic, which has changed the numbers a little bit. And we think that that's a temporary change. But of the people who are under correctional control, 13% are in prison in 2019, and 87% are under supervision. The focus on community supervision means that Minnesota is a low incarceration state. Crime has risen over recent years, but it has not risen to the level of many other states, including those with high incarceration rates. Yet one of the issues is that Minnesota spends the lowest percentage of general fund dollars in the country on corrections. We are last in the entire country on corrections funding. This is a problem and contributes to high caseloads and less effective community supervision. This is a graph that we used in a presentation last year about us being last in community supervision, or not community supervision, corrections funding. Minnesota's right here. I actually looked up the numbers from a more recent survey, and in 2022, we actually spent 1% less from our general fund on corrections. So it was 2.5 in 2020, and now it's 2.4%, and we are tied only with the state of New York. So the way the state funds supervision across the 3 systems is convoluted, difficult to follow, and honestly a part of the problem with supervision practices. The legislature has to make a difficult decision every year, as does the DOC. So you get a request from the DOC to fund institutions, and there's a very strong obligation to fund those. And it's a little bit less clear on the supervision side, especially when a lot of the money goes through to counties. So when you get to the end of session, you have to decide, okay, we have this limited pot of money, we'll fund the prisons, and then if there isn't enough left to fund counties or the state, you have to take care of the state employees. And that's, until we change the way this is funded, it's going to keep being like that every year. I know everybody wants to fund the entire system, but because it's so complicated, people don't always understand that when you fund the DOC, it doesn't go through to counties. But I don't want to focus necessarily on DOC versus counties, because again, this is about our whole state. We all do supervision. We all want it to work well. But here is one of the reasons why it's led to funding inequities. So the blue line in this chart shows county levy dollars, and the green line shows state dollars towards community supervision. As you can see, the state dollars remain pretty consistent, and then they started going down, which basically means as a percentage of the county budget, because state funds haven't risen and inflation has happened, it's a smaller part of the county budget. So that went down, but then the county cost goes up, and that is passed through directly to taxpayers because, or, county property taxpayers, because the way to raise money is through property taxes. It's not only a problem, though, in counties. The DOC, I think only 1 year in the last decade have they gotten enough funding to hire more agents, which means their caseloads are also really high. And to show you how we have come together this session, like, you never hear counties talking about the state being underfunded. But again, this isn't about the state as an agency or counties separately. It's about our full supervision system. So when counties in the DOC have had to make difficult budget decisions, regardless of supervision system, the level of service is impacted. Supervision agents often have very large caseloads and cannot provide individualized or specialized service. The kind of services that often lead to successful outcomes that are expected by both the persons we serve and our communities that we keep safe. Those are often the ones that have to get cut first. And then I have a video. It is a bit long, but it kind of shows you what probation could be and how it's supposed to work. So I will press play, and hopefully someone can give me a thumbs down if the sound doesn't work.
The United States incarcerates significantly more people than any other industrialized nation in the world. And our historic get tough on crime policies haven't had the desired outcome. Over the course of the last 20 years, we've been equipped with a significant amount of research that tells us both what works and what doesn't with the clients that we serve. As a result of that research, we have an obligation to change our approach. And that approach includes both the interventions we offer our clients and the way we interact with our clients. At DFO Community Corrections, we're committed to that obligation, and we're seeing a difference. We interviewed both clients and probation officers to gather their perspective in regards to the work that we do and the change in our approach.
It's not just a client and probation officer. I am a support person, sometimes like a little bit of a therapist.
She really wanted to get to know me, my story, versus kind of just coming in and going over like, oh, this is what you need to do. I had a different agent before who's great, but it was kind of more of the, cut and dry, like here's the things that you need to check off.
I am here to help her, and I want to offer those services that we have, and I want her to be successful.
Giving us choices rather than, telling us what we have to do. She's asked questions about my life versus just not bothering to get to know me, kind of wanting to know about my family history, because ultimately that's kind of the stuff that makes us tick, the reasons that we use.
She didn't probably have the best upbringing with a female role model, so I can partake in a little bit of that role modeling relationship also.
She knows my ins and outs. She's there if I need to call her.
We are now allowing to develop that relationship with the client where their honesty is going to come through, that they want to tell us the truth that they're struggling with their addictions, and maybe do some cognitive reports with them in the office versus always having to have a detention or a lockup or a jail consequence.
Honesty has been going a long way. They're not just throwing us in jail anymore, kind of giving us, choices to make.
I'm still compassionate, I'm empathetic, I'm sympathetic. I feel for these women on my caseload that continue to struggle every day of their lives with success, addiction, relationships. And where I come from, the idea of, with my client, is mainly the idea of empowering the positive qualities for them, giving them positive feedback versus coming down hard on them for things that they struggle with it, mental health and chemical dependency.
I have a whole team of people working for me versus just the probation.
I feel it's very necessary to involve as many resources as possible for my client. I put it in the idea of being, making sure that their structure and their plate is full when it comes to these resources, whether it be holistic, religious, spiritual, physical health. It's not always where you came from, it's where you're going to keep going to, and that'll better serve you and better make you successful as well.
Like now going to meet your PO, I'm not nervous to come talk to her. It's more of a, just like this, just talking with somebody versus I'm scared, like my life is in her hands. No, I have choices and I dictate my future.
And I truly enjoy the relationships, getting to know, I get to know them, what, like I said, motivates them, what are they doing, what are their goals. I get to hear about not just, mistakes and the things that, the roadblocks and challenges. I get to hear about when they succeed.
How you guys look at not just taking the criminal aspect of us into consideration, throwing the book at us. You guys look at us as like humans,
Each relationship is different and each client has different motivators. And I feel like that's really important.
He's been really understanding.
Well, I'm going to give you the keys here and you're going to be the person driving. I'm going to be in the passenger seat, but if I see that you're going to drive a little reckless or if I see you getting ready to drive off a cliff, I will ask you to pull over and I might have to drive for a little bit.
You broke this, and this, we know what your consequence is. My first violation, I know how much time I'd have to go sit. It's a fact that I know that that's already in place. So that pushes me motivation to be like, all right, well, I don't want to go sit that much time in county.
You're able to actually help with other parts of their life instead of just the criminal part.
I didn't have a fear to come and meet with my PO today, and that was cool. That was way cool.
I personally have seen what doesn't work because I've done that with my clients. And when I did that, I had no relationship. They didn't trust me. They ran away from me. And here they come to me when they're in a crisis.
I don't like to open up to very many people. So the fact that she's allowed me to, one, gain her trust and for her to gain mine is actually kind of, it's a new concept, I guess.
Our ability to utilize cognitive behavioral interventions in our office visits have really opened up the doors to communication. I feel like I've just gained a really good relationship with my clients.
Before, it used to be POs and the system locked you up. That was it. So we learned to lie.
So we really put the burden of change on our clients, and we're just a tool that they utilize for resources and getting them from point A to point D.
This is the only office in my whole life I've been on probation and parole that honesty was a big factor.
We are 100% here for our clients.
I went to my PO and she's like, what's going on? And I says, I'm doing the deal, I need help. And she said, okay, I'm not gonna lock you up. You're gonna take the steps. You're gonna get the help. She goes, I will put in just as much effort as you do.
It's not about the relapse that leads to incarceration or any sort of sanction. It's not showing up to me. It's not being honest with me.
They care. They really care. Even the people that lie to them and try to manipulate them, they still care because they understand. They're starting to understand the criminal behavior and the addicts, that we don't do it because we're mean people or terrible people. We do it because we suffer. And that's all we've ever known.
right, I know that's a little bit long, but I think it's really important to show what impact community supervision can have when it is adequately resourced. So we want all of the counties to be resourced so that probation officers have time to create that relationship and do that programming with clients. And I apologize, this says with this bill, it can be, we're not hearing a bill that's from last year, but I really wanted to show that video. So last year, or in 2021, we embarked on the Justice Reinvestment Initiative in Minnesota, where we asked for the Council of State Governments Justice Center to come in and collect data and say, hey, how can we do this better? Because we knew that there were issues and we want to do things better. I'll skip a lot of this, but they held more than 244 meetings with people across Minnesota, meaning clients, probation professionals, tribes, mental health professionals, victim advocates. They did an incredible amount of work. I was in a lot of those meetings, so there was a lot of feedback. They came up with recommendations for moving probation forward in Minnesota. 3 of the recommendations were to create a supervision standards committee, which is kind of to set a minimum level of standards. So like everybody should be at least at that standard, and then also use that committee to kind of work on policies to make sure that we are doing evidence-based practices throughout the state, because those practices are what we know reduce recidivism and ultimately protect victims because people are not committing further crimes. And the second recommendation was to identify a permanent, transparent funding formula that is consistent for each county based on a per diem model. And that is something that I will talk about in a minute. And then add tribal governments to policy and finance changes. So all of these organizations participated in the Justice Reinvestment Initiative, but unfortunately the legislation did not pass last year because there was not a public safety bill agreement. So that means the Council of State Governments lost their grant funding for implementation because there was no legislation to implement. So then the Association of Minnesota Counties created the Community Supervision Work Group to sort of move forward with the recommendations of CSG, because we know it was based on data and we know that a lot of people had a voice in creating those recommendations. So we continued the work. We completed a statewide workload study. It was a lot to finish it in a year, but we did that. We are finalizing a single funding formula proposal on Monday, hopefully, with our group. And we are going to be proposing a bill this session to implement the formula, increase investment, and create a community supervision advisory committee to ensure that there's statewide participation in the policy setting. So the recommendation in 3 steps: complete the workload study through the temporary collaborative committee. So we created that and we did that. Establish one formula with workload study results. We are doing that, but also need your help to do that. And then funding counties to meet obligations. So that's all part of it. The content of this work and the decades-long problems of the system and equities it created, and the unique collaboration and problem solving involved in the solution, it's a lot. Like, there were a lot of details that I talked about. It's not an easy issue, but the bottom line is we are here today after all this work to try and achieve better goals, or better achieve those 2 goals of public safety and helping clients successfully build their lives. We must strive to provide the best outcomes and most successful supervision in the community as we possibly can. We do it for safety of our communities and the wellness of our clients. The majority of clients really want to rebuild their lives to be thriving parts of their communities, but they need the support, resources, and professional levels of supervision to help them succeed. So, key takeaways: this is an historic effort. It's a lot of people coming together to come up with one solution. We believe the result is a fair, transparent funding model that preserves local control and local choice so that counties can do those innovative programs that really have results. And this, funding, the proposal that we will bring later this year through the Justice Reinvestment Initiative recommendations, it creates better public safety outcomes, which ultimately impacts our entire state. So I do have probation professionals on the call with me to answer questions. But I'm guessing you're going to turn it to Commissioner Schnell first. So I will stop sharing.
Thank you, Ms. Stark. Before we go to Commissioner Schnell, I don't see that the PowerPoint is available in our committee materials. Could you provide that for us?
Thank you, Mr. Chair. Yes, I was working on it up until right after this due to our conference. So I will provide that, and I put more detail on the slide so you can look at it later.
Thank you. And then also, could you answer this question? Has the Council of State Governments been involved in any way since they lost their grant funding? Have they had an opportunity to participate in any way in the AMC completion of the work or take a look at their recommendations?
So, well, there's two sides. They had a little bit of grant funding to do some of the work related to supervision standards. So working with the DOC and counties, they've been talking about the supervision standards with probation professionals. They were not involved in the AMC workload study or the community supervision group, though I do still call them to ask questions as we go, since I've been facilitating some of that work. And I think they are interested in becoming more involved and could potentially help with the implementation should the new formula pass.
And the studies that AMC then moved forward with, is that what the Council of State Governments would have done had they not lost their grant funding and you just picked up the ball and to make it happen?
Mr. Chair, yes. We would have liked the workload study to be over a longer period of time, but we knew it was limited. But yes, we hired the American Probation and Parole Association to do the workload study, and we had representatives on the work group from all three delivery systems, including two field services representatives from the DOC, which they're representing field services, and then county commissioners from all three systems, and a tribal representative, someone from the Minnesota Intercounty Association, and then someone from the Minnesota Corrections Association. So we tried to do what the recommendations were with that group.
All right, so you try to do what the Council of State Governments recommended that you do. You just had to organize it yourself and pay for it yourself.
Yes.
All right. Thank you. Commissioner Schnell.
Thank you, Mr. Chair. Paul Schnell, the Commissioner of Corrections. I first want to say thank you to AMC and the Minnesota Association of Community Corrections Act counties and county probation officers for the ongoing work on the study and for the partnership we've had. I think, as Ms. Stark mentioned, when I was a much younger person, just out of college, I can remember conversations happening between the counties, Community Corrections Act counties, CPO counties, and then DOC leaders about funding issues. And this is 35 years ago. And so I think, as Ms. Stark pointed out, this is historic in the sense that finally, I think we're in a place where we come together to try to develop a system that addresses our state's needs as it relates to this. Mr. Chair, I also want to say thank you to you and the committee for taking the time to hear about this issue. It's, as was pointed out, it's complicated, and yet we know that it is about public safety and successful outcomes for individuals and families across our state. The next slide is the Department of Corrections has a unique role in that we provide the pass-through funding as the executive branch agency who is charged with providing an accounting of that subsidy and its distribution, along with ensuring and reporting on system outcomes. The DOC, as was mentioned, is also a provider of supervision services in the counties that choose to have the department provide those services. We have a grants and subsidies unit that is responsible for providing those subsidies, and they also work with the counties in the development of their comprehensive plans for community supervision, which is required of Community Corrections Act counties, and would be something that we would like to see all counties, regardless of delivery systems, participate in, to ensure that counties and county leadership have a level of awareness of what's happening with community supervision across their county. Next, we can show you, it was briefly mentioned, the areas where the DOC provides services. You will notice that in the areas that are the darker blue are the areas that we provide all levels of supervision, both contractually for the misdemeanants and youth, as well as the gray areas, which we provide simply the felony supervision, and the county probation office in that local county provides the misdemeanant and supervision for youth. We also provide intensive supervised release supervision in 75 counties across the state, and then through contract and funding to CCA counties across the state. Next slide. So we as was indicated, there has been a tremendous amount of work. We using a lot of the information that came out previously with the work with the Council of State Governments, the government, the governor and lieutenant governor are proposing in their budget recommendation a substantial increase for community supervision that really recognizes the need for evidence-based practices, sufficient funding in order to meet the needs, and making sure that the state fulfills its obligation for funding to the counties, and then really engaging in tribal governments as a part of the solution here, while recognizing the fact that tribal Native Americans in our state have among some of the worst outcomes as it relates to supervision and criminal justice involvement overall. What the priorities in our recommendation are to maintain these strong partnerships across counties and tribes and all the public safety networks across our state. We also want to, as was pointed out, really need to get to a place of a single funding formula for an investment in supervision across jurisdictions. We also believe it is essential that we are ensuring the effective use of evidence-based practices across the state. We want to and need to, in our state, reduce racial disparities and geographic inequities that exist even in terms of access to services. And related to that, we really want to make sure that there is improved access to community-based services for behavioral or mental health services, substance use disorder treatment, and employment placement services. Next slide. The governor's recommendation, and we will be talking about this, is when we come forward with the budget overall. But you will note that there will be a substantial annual investment in community supervision across the board. $32 million to the Community Corrections Act counties, $5.3 million to CPO counties, and $5.7 to counties that are served by the Department of Corrections. There's also $2.75 million to provide tribal nations with the ability to both provide or supplement probation services in tribal communities across the state. In recognition of the inequities that exist around availability of community-based services, there is also proposed $18.7 million annually for grants to address gaps in services that exist across our state. And we know this, that oftentimes in places where you have fewer treatment programs or other types of needed resources, those people end up incarcerated in our prisons, in our jails at higher rates, simply because there's a lack of available services. Whereas in the metro area, where services may be far more plentiful, albeit in some instances still inadequate, we may be able to get clients served. And we want to make sure that we're addressing these geographic inequities and addressing known gaps in services that exist in our state that would stabilize the people who are on supervision across our state. And then finally, there's in the budget request, there's $1.6 million a year for the creation of intervention centers. Intervention centers are used for those people who may be subject and struggling on supervision. And as opposed to using prison or secure custody as a means of stabilizing them, these regional intervention centers would be used. They would be staffed and using evidence-based practices to work to stabilize and get them back out into the community at less cost, really, and ultimately more effective interventions than you might see by placing someone in prison for a period of 60, 90, or 180 days. Next slide. When all is said and done, Mr. Chair, members, we believe strongly that if we need to focus on the goal, and that is about a safer Minnesota, investment in supervision, as Ms. Stark pointed out, and I hope that I drive as well, is really grounded in making sure that we have a system, starting with the courts, which is where this committee started its work today, all the way through, and our law enforcement partners. And when all of these segments are sufficiently resourced and have what is necessary and can function as a system, we believe we can produce better outcomes for the safety of our state. And with that, Mr. Chair, I would conclude and stand for any questions along with Ms. Stark and others on the call.
Thank you, Commissioner. I have a number of others on my list of testifiers. So why don't we just go on to them, and then members can hold questions till the end, because some of your questions might be answered by the additional testifiers. The next person on my list is Molly Bruner. Is Molly Bruner here?
Mr. Chair, I think she is around for questions.
Okay.
Unless you prepared testimony, Molly. So Molly, Mike, and Tammy, no, not Tammy Jo, Nicole Kern are online for questions.
All right. That's wonderful. Thank you. Then let's just open up the floor for conversation here among the members of the committee. I will say, to sort of open up this discussion, that this has been an issue for decades. It's gone through Senator Limmer's chairmanship, my previous chairmanship, and every year I'll speak for myself, I've felt at the crossroads of interpleaders from each of the various county groups that are involved in the DOC, all of whom seem to have obviously their own ideas on how to address these concerns, and never feeling like I was in a good enough position to be the arbiter here. And so I've kind of felt like it ought to have been back among the systems involved to really pull everything together and figure out what's going to work best from the system and see if they can come up with a common proposal. It's one reason I was excited when we finally had all of the justice partners willing to have the council of state governments participate here and get this process rolling. And I'm also excited then that the ball was picked up by the AMC when we reached an impasse last spring. So I guess this is a good development. I'm very curious to see a little more detail as the recommendations proposal comes out. I know it's a heavy lift from a budget standpoint, which has always been part of the problem in terms of legislative action and funding. But it's good to have numbers and recommendations, a proposal for us to work off of as we try to address this. And this is the kind of thing which I think it would be really, really helpful for us to have a strong bipartisan consensus on how to move forward as well. I always prefer to do it that way, but this is one of those areas in particular where I think it'd be very helpful to do that. So I'll leave my comments for now at that. See if any other members of the committee have anything they'd like to add or any questions they would like to ask.
Senator Latz.
Sorry, Senator Limmer, go ahead first, then Senator Pappas.
Thank you, Senator Latz. Just to make a few opening comments, it was interesting to get a little snapshot of what has been discussed. I was interested in seeing Minnesota as being spending the least amount of dollars in corrections compared to 50 states. That's how it opened up. I would assume we probably don't spend as much in incarceration as other states do, so that could be a major factor in that. However, I would like to know if there was a breakdown nationwide for the dollars we spend in supervised release. That really is what we're needing to focus on. But nevertheless, in my discussions with counties and county probation services, there's a very strong feeling from them that they would like to maintain a sense of autonomy when it comes to probation services, and hence the 3 delivery systems seem to continue to be healthy. But when I hear discussions of a funding formula, I don't know if that's necessarily a per diem or per person type formula. I'd be interested to know how that's going to be created. And then some kind of statewide standard is also another question. And does that erode that degree of county individuality in dealing with those on supervised release? Has there been any discussion about that?
Who wants to tackle that? Ms. Stark, Commissioner Schnell? Ms. Stark.
Thank you, Mr. Chair, Senator Limmer. So I'll answer the formula question first. So the way the formula would work, and this is just a snapshot. So there would be a base amount for each county. We're thinking approximately $250,000 or $200,000. And then we would take 10% of the previous year's total appropriation for community supervision, distribute that based on population. Another 10% would be 10% of the previous would be distributed based on geography. And then the rest of the amount would be based on a capitated rate, which is basically how much does it cost to supervise one person per day on supervision. So we came up with that amount, though, not based on case type. We did it based on risk level. So it takes more staff to supervise high-risk individuals because that's more intensive supervision. So we took an average of the larger per diem for those individuals and the smaller per diem for low-risk individuals and medium, and we kind of averaged it together. And then that is applied to the probation population. Was it even 100% for felonies and then 50% for misdemeanors?
I'm sorry, Ms. Stark, I'm going to interrupt further. Someone has turned their mute off, so we're hearing background noise. Could all of you please check and make sure, if you're not the one speaking, that you are muted? Thank you. Ms. Stark, did you have anything else to add at this moment, or shall we go back to Senator Limmer?
That is all on the formula, and I actually think the background noise might be for me, so if you'll give me one moment.
Oh, that's not a problem. If it's you, that's fine. But
thanks, Mr. Chair.
all right, go ahead.
So the second part of the question was related to the supervision standards. So we believe that everyone should be doing evidence-based practices. And right now the resources haven't been adequate for everyone to do those practices. So we're hoping that the resources help bring all counties up to be doing fidelity to evidence-based practices. But the way the standards would be sort of developed is through a community supervision advisory committee. And it's a committee that includes representative from all of the systems, including county commissioners from all three systems, probation, DOC, mental health, tribes, and a few other individuals. And that group is supposed to be advisory to the Department of Corrections. It's not like the sentencing guidelines where you give advice on policy changes, and if the legislature doesn't vote, it goes into effect. But we built in some transparency there, both with the advisory committee and with the Commissioner of Corrections, where the advisory committee gives recommendations, and the Commissioner of Corrections, if they don't implement the policies or support them, they have to tell the committee why, give a report within 45 days to the advisory committee, but also to the chair of public safety in both legislative bodies. So it creates a broader view of what we think probation should look like in Minnesota from all the stakeholders.
Senator Limmer.
A real quick recommendation on your last statement is, in addition to the report to the chairs of those committees, perhaps a copy to the ranking member of those same committees would be a nice addition. We usually do that with any and all reports when it comes to this type of thing. The other question would be, there at one time was a desire by the Department of Corrections to take over as a singular unit, supervision or supervisory release, and that they would establish the standards and expectations rather than allow the counties to be a little bit more independent. How does this trigger that by the establishment of increases of dollars to the Department of Corrections so they can give money to the counties, and also a singular set of standards created by the Department of Corrections?
Mr. Chair.
Commissioner Schnell.
Mr. Chair, Senator Limmer, I think as Ms. Stark pointed out, I think we really want the system to function together. We want there to be consistency of practice across all systems. We want to be in a position, certainly, just representing the DOC. And again, we are a system. We are not we don't want to work against one another. That's the last thing that serves the interest of our state. We also do recognize the Department of Corrections as the department. We do recognize that at least my role is to make sure that we're providing the data to you around transparent expenditures of dollars and what that looks like, and those standards and our outcomes. And certainly that there is one place that comes through, and it typically comes through the one of the state agencies to provide that data back to the legislature. And that's what we're really talking about here. We're not talking about, we want counties. And really, I think the essence of the Community Corrections Act was in fact to give counties a larger level of voice in terms of the integration of these services, correctional services, with the other services that counties provide. And we are 100% supportive of that. When we take our direction from the counties, a county can choose to move to a system other than the DOC at any time. And we're 100% supportive of that if that is their choice.
Okay. I noticed, Commissioner,
Senator Limmer.
pardon me, Mr. Chairman. I noticed, Commissioner, your words that said a county that choose to use the Department of Corrections gives me hope that there would be more independent nature for the counties, as well as a statement, regardless of delivery services, the Department of Corrections wishes to pursue these same goals of strong partnership, a $1 formula, evidence-based practices, reduce racial disparities, and other subjects. So I'm at least picking up hints that the 3 delivery services would be the choice of individual counties. And I would imagine those 3 delivery services have maybe 3 different ways of pursuing these goals. And so I know that the DOC comment was number 1, create a pass-through and oversight. Number 2, the Department of Corrections is creating a field service unit. And so is that just an oversight function, or is that a supervisory function?
Mr. Chair, Senator Limmer, when we talk about the oversight function, it is about the reporting requirements that the department has as established by the legislative bodies. And that really is fundamentally our core oversight function. We do some work with comprehensive plans, but that really works in accordance with, the counties have their own advisory committees that operates through their county board, comes in into the department. So that is established in Minnesota law. The field services, when we talk about field services is really just a word for the DOC's probation services that we provide should the county, if the county chooses to have the Department of Correction provide supervision in their jurisdiction. And again, to your earlier point, this is and has been in accordance with Minnesota law always about the county's choice. A county can choose to, we're making it easier with this. They could choose to become, Community Corrections Act county. They could choose to move to the split hybrid model of a CPO. That's what this funding formula really, I think, allows, makes it much easier for counties to make those choices because it is the capitated rate is grounded in the numbers generally.
Mr. Chairman, just one last question. The tribal inclusion, is that, I don't recall that that's been something that we've done before, or is it? Maybe you could expand on that a little bit for me.
Mr. Chair, Senator Limmer, yeah, that is new. I think it is something that has been a shared priority. I can tell you that, we have, in accordance with now Minnesota law, been engaged in tribal consultations with tribal governments across our state. And we have heard loud and clear about the importance of wanting to make sure that those governments have the ability, and those communities have the ability to further support, and they want improved outcomes for the peoples in their communities, and so this base level of funding would allow them to be more targeted in those services. Potentially, they could collaborate with a county. I can tell you that one tribe, should this become law and the appropriation granted, they would like to create a strong partnership and collaboration with the Arrowhead Regional Corrections, the Community Corrections Act area, and together they would more focus those services with the whole goal of achieving better outcomes for the Native American people in their community. So this is really about wanting to make sure that we're doing better on that front, and recognizing the sovereignty of those governments. And really the opportunity for them to have voice and to serve the people that really belong to those communities, as well as the broader Minnesota community.
Mr. Chairman,
Senator Limmer.
There's always historically been a little bit of a reticence of partnering from a non-tribal government, meaning the state of Minnesota. There's always been a little bit of a reticence in recent years of how far do we go to partner with tribal communities, but it really is important get the tribal communities to buy in or to agree to what we as a state may offer. And it can't be something that we hold over some type of other, whether you call it a government program or a quid pro quo or anything like that. We really can't do that. It has to be an open presentation to Indian tribal communities, and they can investigate what the state may offer, and it would be up to them to openly agree to do that. And there may be some cultural customization on it that recognizes their tribal traditions, but nevertheless, I like to see the tribal inclusion in this. And I know we only are scratching the surface on this proposal, but I am curious to see the other elements in a little more detail, because it's something, as you said, Mr. Chairman, this is something that we've kind of chased for a number of years. We've never really gotten down to it. One last question to Ms. Stark. Ms. Stark, there was a question as you tried to outline this formula. What does this formula do with that old statutorial commitment that the state made to cover 50% of supervisory costs? Do we repeal that and remake the whole formula? Before, it was a 50% commitment that the state never really fulfilled, but it was with the idea that the counties individually would cover the other half themselves. So tell me what the vision looks like with that 50% past commitment. Are we jettison that in exchange for the new formula?
Ms. Stark.
Thank you, Mr. Chair. Senator Limmer. We are still working on that. I know the version of the bill last year had that language lined out or struck through because the new formula sort of takes its place, because we put the new formula language under the Community Corrections Act and then made sure everybody was eligible for funding under that formula. But what we've been talking about in our work group is in using the capitated rate, having the state fully fund felonies and then work into the formula somehow 50% funding of misdemeanors. So that is part of the discussion. We're ironing out the details of exactly how the language is part of the new formula, which we're getting very close.
All right. Well, I'll look forward to seeing the big picture. Thank you, Mr. Chairman.
Senator Pappas and then Senator Seeberger. Senator Pappas, go ahead.
Thank you, Mr. Chairman and members. I just have a very simple question for either Ms. Stark or Commissioner Schnell. If we limit probation to 5 years, and I know the Sentencing Guidelines Commission had talked about that. I don't know if it was implemented yet. Is that going to have any kind of financial impact on the cost of providing probation services? Do we know anything about that? Do you?
Mr. Chair.
Commissioner Schnell.
Mr. Chair, Senator Pappas, yes, the sentencing guidelines, the cap at the 5-year cap was put into effect as a sentencing guidelines policy, and that is, in fact, there certainly is ways for courts to extend that as grounded in the guidelines, but it does contain to some degree some of the costs that can go on if people have extensively long probation periods. So yes, it is in effect. We haven't really realized or seen what that impact is yet because of COVID impacts and so forth. But it's something that the Guidelines Commission would like to look at and see what does that look like because of that change in policy.
Thanks.
Senator Seeberger.
Thanks, Mr. Chair. I just wanted to chime in and say that I've been working with Ms. Stark on the Senate version of this bill and hope to have it for you or hope to have it dropped here soon. The House file is 1838. So I know that the stakeholders have been working really hard to get this formula just right, or as close as they can to just right. And I look forward to bringing it before the Judiciary Committee when it is after it's been introduced.
Very good, Senator Seeberger. Senator Limmer, your hand is still up. Was that, you have another question, or did you just not remove it? Any other members of the committee wish to say anything? Senator Stark, your hand, or Ms. Stark, your hand showed up as up.
Yes, I just wanted to let members know that if you look at House File 1838, it does have placeholder language for the formula. So the goal would be to replace that language as soon as we have it done. We've been working on the workload study. We got the data back officially last week. So we wanted to make sure it was data-based. So you'll see mostly placeholder language.
All right. I'm not seeing any other hands up right now, but I might be missing something. Does anyone else from the committee have any questions or comments they'd like to share? Ms. Stark, Commissioner Schnell, anything you'd like to add before we wrap up our conversation today?
Just a hearty thank you for the opportunity to just walk through this. And again, my appreciation to you, Mr. Chair, and members, and to AMC and Ms. Stark. And the two associations for all the work that's been put into this.
I'll just echo that thanks and also say, we would have loved to have commissioners here because this is a big priority for our association. We are on our way to getting 87 county resolutions in support of this new formula. From what I've heard, the only reason we don't have 87 yet is because our emails don't always go through county IT systems. So we'll have a packet of those for you soon.
All right. Well, then, thank you, Ms. Stark. I think that will wrap up our discussion on this item. And this is our last agenda item today. So members, thank you for your participation here on a Friday. We have obviously lots of work left to do on this topic and more bills in the pipeline for next week. So have a safe and healthy weekend, and we'll see all of you on Monday. The Judiciary Committee is adjourned.
Thank you, Mr. Chair.